Good morning, all. This application hearing is in the matter of CFI 079-2023 and is being held by way of video conference before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by White & Case. Lead counsel is Mr. Ravi Jackson. The second defendant is represented by Habib al-Mullah and partners. Lead counsel is Mr. Stephen Docherty. Thank you, Your Honour.
All right, thank you. Mr. Jackson, Mr. Doherty, have you discussed how we're going to proceed with this hearing today?
We haven't, Your Honour. There are obviously two applications before the court, one made by both claimants and the first defendant. Both parties have set out their position on the applications in detail in their skeletons. Subject to Your Honour, what I was going to suggest in terms of the most efficient way to proceed is for us to take each of the requests in turn and for the parties to make submissions and Your Honour to rule on them as we go. I think that'll probably be more efficient than us making sort of general submissions on the applications. As to the order of the applications, I'm in Your Honour's hands. Both parties have addressed the first defendant's application first in their skeletons, probably because it's the meatier of the two. So Your Honour may wish to deal with that first, although it shouldn't make any substantive difference which way we deal with them.
All right, Mr. Doherty, what do you say?
Yes, I was going to suggest much the same. We have both dealt with the first defendant's application first in the skeleton, and so perhaps we could start there because there's a bit more ground to cover. The only slight tweak to that is in addressing you in oral submissions, I had proposed potentially to take some of the requests out of sequence, but where there are common issues, where there are common formulations to the requests. So, for example, 1, 4, 5, and 7 raise common issues, and it might save some time going over those common issues in oral submissions if we sort of work through them in that sequence. But if we were to begin with the defendant's application, I can suggest that sequencing as we go.
All right, well, I think that's consistent with what Mr. Jackson was proposing, so let us proceed in that way.
Certainly, thank you, Your Honour. The first cluster, if I can put it that way, and I'll work through them in this order, would be dealing with requests 1, 4, 5, and 7. And those are the requests which cover documents relating to shareholding structures and management arrangements for various of the companies. So request 1 relates to documents held by the first or second claimant relating to the ownership and management of Al-Khalij, an entity in Saudi Arabia, which includes certificates of incorporation and documents showing the shareholding structure, including the shareholding structure of any parent company. And there are 3 aspects to how I understand the claimants object to this request. So a point is taken on possession, custody, and control. A point is taken on materiality and relevance, and another point is taken on the breadth of the request. So I'll just simply work through those in turn. When it comes to possession, custody, and control, a point was taken in the response to the request to produce that the claimants didn't have possession, custody, or control of documents which were otherwise under the control of Al-Khalij. Now, it's unclear whether or not that point is still relied upon or not, or whether there's a possibility of cutting through. I don't think that the point is taken in my learned friend's skeleton. So,
well, I think it might be quick. I'll ask Mr. Jackson, what is your, not your argument, but your position on that matter?
Yes, we don't take a point on possession, custody, and control for the purposes of this request, or I think the other requests that Mr. Docherty is going to come on to. The objections that we do take are the ones set out in our responsive evidence to the application,
which are materiality and the breadth of the request.
Yes, they differ slightly in terms of some requests, but
all right. Well, thank you, Mr. Jackson. That's helpful. Yes, Mr. Doherty, back to you.
Yes. Thank you. That's quite helpful. That probably cuts out a bit of what I needed to refer you on to this morning. On relevance and materiality, as I understand it, the sole basis on which the claimants challenge relevance in respect of this particular request is based on them having made what we would characterize as a limited admission in its pleadings to date, that the first claimant is either the whole or majority owner of a company called Jura Holdings, which owns Al-Khalij. And in effect, that's in response to the first defendant's pleaded case in those terms. But all that's
So
admitted
what
is
exactly
one
is
or the
your
other.
Mr. Doherty, what exactly is your plea?
Yeah, so page 31 is the bundle, and I'll take you through.
See how well the internet's going to work for us today.
Are you working off the electronic bundle from the website?
I am working off the bundle, yes, and I've got it. Page 31.
So from paragraph 56 onwards is the section which begins with explaining the involvement of Al-Khalij in the dispute. Paragraph 57 is the plea that Al-Khalij is owned by Jura Holding Company, which is a company registered in Saudi Arabia that is wholly or majority owned by the first claimant or his family members, and that the second claimant is an employee of Al-Khalij. And the point made really about relevance is that the claimants say, well, they admit this paragraph, so there's no live dispute. And the first defendant's position is that admission, or as we would put it, a partial admission without explanation, is hardly the end of it. And there are a number of aspects to that, but even on its face, what the first claimant hasn't told us is whether, in fact, he wholly owns Jura, and if not, what the precise nature of his interest is. Nor do we know anything about the role of either claimants in the management of the company, which I'll work through the pleadings on this issue just so it should be clear to Your Honour how Al-Khalij is relevant. So as one works through this pleaded section that you have up, for example, we see the reference to the fact that Al-Khalij historically had acted as a distributor for the medical software Medica Plus and Medica Cloud Care, which had been rolled out through Al-Khalij across a number of facilities in Saudi Arabia. And that was through the relationship that it had with the second defendant, who was, on the first defendant's case, a partner reseller of those pieces of software, and that they had the license to authorize use of the software in particular territories. So in this case, the UAE and KSA.
Can I say to you, Mr. Doherty, that we put a high level of generality, I understand the defendant's case or defendant's counterclaim to be that Al-Khalij withheld payments to the second defendant, causing significant revenue loss, and the claimants diverted business from the second defendant to Al-Khalij and to other companies associated with the claimants. Do I need to go much more detail than that?
No, potentially not. It depends really rather on what view Your Honour has taken on the relevance and materiality of this request. We say that it should not be that controversial, particularly where, for example, in the pleaded case, so for example, paragraph 82, if you were to skip forward in this document.
Yes, I have it.
The basis upon which the claimants are said to have had a direct or indirect interest in transactions associated with Albulaihid. So that's the continued licensing and use of the software, arises as a consequence both of the fact that the first claimant or his family are the owners or ultimate beneficial owners of a majority of Albulaihid's shares, or in the capacity the first claimant is understood to have as the general manager of Albulaihid. And so again, the reason we say that the partial acceptance or the admission that the first claimant is either a whole or majority shareholder is only really just that. It's partial. It's not a complete answer, nor is it the evidence required to establish precisely what his shareholding is, whether he's the whole owner. But it also doesn't answer this point about his management role in the company, and therefore decision-making power with respect to Albulaihid, and the response to that in the defence is paragraph 57, but in effect it's we put you to proof in respect of paragraph 82 of the plea. And the same point arises in respect of paragraph 92 of the particulars of claim, which is a repeated assertion about the conflict due to this relationship with Albulaihid.
Yes.
So we don't know the detail of the shareholding is the first point, and that goes directly to issues arising on questions of liability in this case. But it's also relevant to remedy. And again, there are two parts to this. So there's a plea requiring the first claimant to account. And we say that would require consideration of the nature of his interest in Albulaihid, and for example, whether that company is simply an alter ego and one that he would need to account for all of the profits for. But if not, one will need to understand precisely what level of control the first claimant has over that company if we're considering an account,
Yes.
which would potentially inform an action. But also there's a alternative proposition put in the unfair prejudice petition, which seeks to enable the first defendant on behalf of the second defendant to bring an action on behalf of the company. And if there are issues involving not only the first claimant, but also potentially other members of his family having shareholdings, this type of documentation is going to inform what those permissible actions might be and who they might be against, because it might well be that there are causes of action not only against the first claimant, but potentially other members of the family insofar as they have received funds that ought to have been paid to the second defendant, and action is going to need to be taken to recover those sums.
All right.
So that's relevant to materiality. When it comes to the breadth of the request, Your Honour might have noted that the claimant's arguments in this point have evolved somewhat over time. The initial objection that was made at the time the request to produce was filed, if you wish to look at it, it was a page 120 of the bundle, but in effect all that was said was no date range has been specified in the request and therefore it's too wide. And the main objection really at that time was the argument or the point taken on possession, custody and control of Albulaihid documents. In the response to that made through the first defendant's application, a date range was then offered. And so the arguments we now have about breadth have been taken, one might say, belatedly in, for the first time, Ms. Roshan's statement in response.
What is the date range which you now propose, Mr. Doherty?
Yes, sure. It's, sorry, bear with me. I'm just opening my skeleton. There are different date ranges for the different requests, so I don't recall it's on my head. It's from, excuse me.
is the 1st of January 2016 to present.
Yes. Okay.
Thank you, Mr. Jackson. Now, that date range has been offered. The first defendant's position on this is that, of course, we don't have direct knowledge of the dates in which these documents were created. The first claimant presumably does. The documents themselves shouldn't be particularly difficult to identify insofar as, by way of example, in the bundle, one can see equivalent documents having been identified in respect of the second defendant. So, for example, from page 276 through to 282, there are a run of documents which have already been adduced with the first claimant's initial witness statement filed in these proceedings. And those are the sorts of documents which have been adduced to outline, amongst other things. So 276, it's the shareholding structure. 277 shows how the shareholding structure and the directorship of the company has changed over time. Page 279, there are share transfer forms. At page 282, there are board resolutions in respect of changing the general manager of the company. These are documents which you can see, for example, at 282, we're looking at documents that are dating back on this part of the case to 2007. So it's not, in truth, a request which is overly broad. The claimants ought, in the capacities that they have in those companies, to know where there are documents which show the shareholding structure and where there are documents which show the current management of the company. It might well be that there is a superficially broad date range, but it's only because of the first defendant's lack of knowledge as to when these documents would have been created. But that doesn't mean that they're difficult to source or difficult to identify, or that the request is overly burdensome to deal with. We say that the request is sufficiently narrow. We also note the regime in Part 28 is at least notionally intended to inspire cooperation. And if the only issue had been, well, this is a broad set of requests, what a cooperative approach would have looked like would have been to say, well, we will produce you these 4 documents, which will show you the shareholding structure and the current management. Are you satisfied with that, or do you require us to carry out a broad research? That's an approach that, for example, the first defendant has adopted in respect of some of the requests that have been made of him. And the claimants haven't sought to deal with it in that way. The only concern, as I say, they raised initially was about dates. And when those dates were offered, they came up with some new reasons not to agree to the production of the documents. The main argument, as I say, previously advanced has now been dropped. But the position all along seems to have been premised on, we're going to reject this request rather than we're going to make any genuine attempt to narrow its scope. And if there had, at an earlier point, been that suggestion that, well, this is too broad, but we'll provide you with a more limited category, most likely the response would have been what we said in respect of request 7, which was, okay, well, provide us with a copy of the trade license and a document or a handful of documents showing who the shareholders are and who the general manager is. But those are the points really in response to request number 1. I don't know whether you want to hear the response on request 1 or whether you want me to deal with this run of common documents.
Well, I think we'll deal with this one and then go on to see
Certainly
how that flows on to the others. So we might I might hear from Mr. Jackson on this first request.
Thank you, Your Honour. I invite Your Honour to dismiss this request for 2 reasons. The first is that the request is unduly broad and disproportionate, and the second, that it lacks sufficient relevance and materiality based on the parties' pleadings. And I'll work through those in turn. If I can start with the point on breadth, Your Honour will no doubt be familiar with the relevant legal principles, but just to remind Your Honour, if you could turn up my skeleton at paragraph 5, where I've quoted RDC 28.17, and what that requires so far as it concerns breadth is that the request to produce identify a description of a requested document, i.e. a particular document, or a description in sufficient detail of an error in specific requested category of documents. And at paragraph 6, I've quoted the Thamer decision from 2010, which somewhat expands on those requirements by saying that a request to produce must be focused. Now, the first defendant in its skeleton also emphasises those particular requirements. And if Your Honour would look at paragraph 28 of my learned friend's skeleton,
yes,
under the heading threshold requirements, my learned friend quotes RDC 28.17, and then at paragraph 31 over the page, he cites Thamer for the same proposition, that requests, as I did, that requests must be properly focused and not cast unduly broadly. And he gives an example of a request that was rejected in Thamer. So in short, both parties have agreed that it's a threshold requirement for a request to produce to be granted, that it is sufficiently specific in the terms required by RDC 28.17. Now, in relation to this request specifically, there are 3 points I make as to why I say it's too broad. The first point is that the language of the request that's used is clearly, I say, on its face, too broad and not compliant with RDC 28.17. And if I could just break each part of the request down, if Your Honour wants to look at the request, it's at page 105 of the bundle.
Yes, I've got a hard copy of the defendant's objections. Oh, sorry, the other way around, isn't it? Wrong document. No, that's right. Quest 1, documents relating to the ownership and management of Albulaihid, and so on.
Yes. So is Your Honour looking at the defendant's request to produce for another document?
I'm looking now. This is not sure what document it is, but it's got the reference, the description, and the objections.
Very good. Well, I think Your Honour has the wording of the request in any event.
I do.
But if I could just break it down. So it starts with the word documents. That is self-evidently not a specific document or a narrow and specific category of documents on its own. What it means is any type of documents whatsoever. So that is, in my submission, a poor starting position for a request to produce. One then has the wording relating to. And the reason I say that's problematic, and it's one of the objections that the first defendant himself took to one of our requests, the reason it's problematic is because it requires the document reviewer to perform a subjective assessment of whether a document relates to the subject matter of the request. So what the document reviewer will have to do is consider whether this document relates to the subject matter. In terms of the subject matter, that's captured by the words ownership and management of Albulaihid. And in my submission, that is very broad in terms of its subject matter. Now, the thrust of, I think, my learned friend's submissions was, well, that's limited to the identity of the people who are owning and controlling Albulaihid. But that's not what the request says.
Well, more than that, the identity and the extent of their either legal or beneficial ownership.
Yes, that's fair, Your Honour. But the wording of the request goes much broader than that, because if one takes it on its face, documents relating to the ownership and management wouldn't be limited to just identifying who owns Albulaihid and the extent of their interest. Management, in particular, would on its face cover the day-to-day operations of Albulaihid. And it's obvious in my submission that many of the day-to-day operations of Albulaihid are likely to be wholly irrelevant to the issues in dispute. So that deals with most of the wording. One then has the date range, which is a very long date range of over 9 years. So on its face, what the claimants would need to do in order to produce documents relating to this quest or search for documents is search for documents over that period which in any way relate to the ownership and management of Albulaihid in the broad sense that I've described. So for those reasons, in my submission, the language of the request is too broad. And the second point I make in relation to the breadth is that the analysis I've just submitted is consistent with D1's, with what the first defendant says in relation to the claimant's application. So if Your Honour could turn to my learned friend's skeleton at paragraph 130.
Yes.
So this is in the context of the claimant's application and the claimant's request 10 and 11. And Your Honour can see the original formulations of request 10 and 11 are quoted at paragraphs 130 and 131. And then at paragraph 132, my learned friend says those requests did not come close to meeting the threshold requirements under RDC Part 28, and are precisely the sort of unfocused and broad search terms contemplated in Thamer, which would necessitate cumbersome and disproportionate search. And if one looks at the wording of request 10 and 11, it's very similar in substance to the type of wording that my learned friend invites you to approve under his request 1, because it's all documents relating to a broad subject matter over a relatively lengthy period of time. The difference between the parties is that on our side, we have narrowed request 10 and 11, and I'm sure we'll come back to those. But there hasn't been any movement in terms of the way that the first defendant formulates request 1. So what Your Honour has is a very broad and disproportionate request that hasn't changed since the defendant first made its request to produce, save in respect of the date range point. Now, if I could just work through some of my third point on breadth, if I could work through some of the points my learned friend made in his submissions. I'll deal first with a few points that he raises in his skeleton on this. If Your Honour could go to paragraph 60, subparagraph B of my learned friend's skeleton.
Yes.
And Your Honour will see in the final sentence of that, what my learned friend submits is that the request is for a limited category of documents concerning the ownership of specific entities. For the reasons I've submitted, we say that's not right. That's not what the request says on its face. And in the about halfway down, my learned friend makes the submission that he also made orally, that if the claimants had any genuine concern about the breadth of the request, they would have offered to provide specific documents. And he cites examples of certificates of incorporation, shareholder certificates, or other company documents. Now, I accept, of course, that the parties have a duty to cooperate in terms of the document production process, but that can't be overstated. The effect of RDC 28.17 in my submission is that the onus is on the party serving the request to produce to ensure that it formulates a properly compliant request from the outset. So any party serving a request to produce needs to come up with the specific document or categories of documents that it is seeking from the other side. And that is what, in my submission, the first defendant hasn't done in relation to this request. So it hasn't complied with RDC 28.17. And it doesn't answer that point to say, well, the claimants haven't identified specific categories of documents. Not least because my learned friend in his oral submissions identified the type of documents that he said might be relevant to this request. And he took, Your Honour, to a resolution of shareholders. And he mentions them in subparagraph B here in his skeleton. So what the first defendant could have done is formulated categories of likely documents that it considered were appropriate, but it hasn't done that. The final point I just want to address on breadth is the point my learned friend made that orally, that the arguments on breadth have been taken belatedly. I don't want to spend too much time on that. I think it's probably relevant for costs if we get there. But it's just to say that we don't accept that they were taken belatedly. They were taken in our evidence in response to the document production application, and that was filed on the 6th of February this year, so over 2 months ago. If I can move on then to the second reason why I say Your Honour should dismiss the request, which is lack of sufficient relevance and or materiality. There are a couple of points I want to emphasise on the law in respect of that. And I won't repeat these for all of the requests, but given that this is the first request that we're dealing with, it may just be helpful to. Your Honour, paragraph 9 of my skeleton, I've set out the grounds on which a party may object or a party may object to a request to produce. And that, of course, includes lack of sufficient relevance or materiality. In my submission, the word sufficient there is important because what it indicates is that the court needs to make a value judgment as to how relevant and material the document will be. And in my submission, this is a request which lacks sufficient relevance and materiality based on the party's pleadings. And Mr. Doherty earlier took you to his client's defence and counterclaim at paragraph 57. It may just be worth us turning that up again. This is at Underlay tab 4, page 31.
Yes.
And Your Honour has there the plea as to the alleged ownership of Albulaihid by Jura Holding, and the plea that Jura Holding in turn is wholly or majority owned by the first claimant and or his family members. And that's a plea that we admitted, as you saw, in our reply and defence to counterclaim at paragraph 31, which is Underlay tab 5, page 50. Now, the point in relation to this is that if one looks at the actual wording of the request again, documents relating to the ownership and management of Albulaihid computers and electronic systems, the ownership and management of Albulaihid is not in dispute on the face of the pleadings, because the plea that's advanced by the first defendant is that it is owned by Jura Holding, and that's what we've admitted. Now, what my learned friend says is, well, our admission doesn't go far enough, but we've responded to the pleaded case that the first defendant has chosen to advance, and there hasn't ever been any request for further information or request for further particulars by the defendant. So we say on the pleadings, this is a request which lacks sufficient relevance and materiality. Your Honour, those are my submissions on request 1, unless I can assist you any further.
Right. No, thank you. My view, request 1 should be answered. I must read the request in the context of the case and having regard to the overriding objective. Mr. Jackson says first that the request is too broad. Requests may, of course, go to categories of documents, and the expression documents relating to is a permissible form of description, provided that the subject matter to which the documents relate is sufficiently identified. In my view, it is sufficiently identified. The ownership is referring to the legal and beneficial ownership, the identity of the owners and the extent to which they have a legal or beneficial ownership. So far as management is concerned, my view looked at in the context of the pleaded case and the matters which arise in the dispute, matters relating to the management refers to the management structure, hierarchy and powers. It does not refer to the day-to-day operations of the company. When looked at in that way, in my view, the category is not too broad. It is often the case that, if not always, that the party to whom the request is addressed must form a judgment as to whether a document falls within or out of the category. In this case, I don't consider that that will be a particularly onerous task for the claimants. As I have said, the class does not extend to documents relating to the day-to-day operations of the company. It doesn't refer to management in the sense of ordering stationery or whatever. It's referring to the management structure, powers, hierarchy as arise in the case. Secondly, so far as relevance and materiality is concerned, I consider that the request or the subject matter is sufficiently relevant and material. Mr. Jackson refers to the plea in paragraph 57 of the defence and counterclaim, which is admitted by the claimants, but that is not the only plea in the defence to which the request is relevant. It goes also to the matters which Mr. Doherty has identified, which go to the interest of the claimants in the company, how they hold those interests, which go to questions of account and so on, as Mr. Doherty has identified. Secondly, paragraph 57 does not, of course, refer at all to management of the company, and that arises in various ways, including paragraph 82, to which Mr. Doherty made reference. There is not an admission that the first claimant controls or manages or is the general manager of Al-Khalij or the control of them. In my view, the request is sufficiently material and relevant. I will require the claimants to answer the question with the added date range that Sir Doherty is referred to. And as I have said, it will be understood in the way in which Mr. Doherty advanced it and which I have referred to, and it doesn't extend to having to produce documents which go to the day-to-day operations of the company. All right, I should say at this stage, so that you can make sure you've got adequate notes, at the end of the day, I'm going to ask Mr. Doherty to, or those instructing you, to produce a minute of the orders on your application, and Mr. Jackson and those instructing you to produce a minute of the orders on your application. So please bear that in mind. All right, what's the next request, Mr. Doherty?
Thank you, Your Honour. I was going to go to request 4. I just apologise in advance, Your Honour will probably note that my voice is breaking. I think it's a week at home on Easter holidays with the kids around has done a number. Well, so if I break every so often, moment, that's why. Mr. Doherty. Yeah, a cup of tea is helping. Request 4 is similar, save insofar as one can substitute out Al-Khalij and substitute in Health Insights Egypt. So that's the company called Health Insights for designing programs. And of course, much of it will traverse the same grounds as it comes to relevance and materiality and particularly breadth, which I don't intend to go over again. The further points that I had intended to take Your Honour to were some of the aspects of the factual background briefly to show you where this fits in, and then the pleadings. And then there's a new point taken about possession, custody and control. And my understanding is that this is a point which appears to be maintained, so I'll run through that. On the factual...
Just a minute, let's start with breadth and materiality. Mr. Jackson, is there any relevant distinction in this request to request 1?
So in terms of request 4, Your Honour, our objections are breadth and then also possession, custody and control, insofar as the request relates to, well, no, the whole request relates to HI Egypt. So those are our 2 objections.
So it's breadth and custody.
Yes, there's not an objection on relevance and materiality in this request.
All right, Mr. Doherty.
Well, it may be that if there's no objection on relevance and materiality, I don't need to take Your Honour to any of the sort of factual background. So long as that's clear, I can move on. Breadth, I think the points are identical and in fact were advanced in the same way. So I think it was initially in the response to the request to produce an issue taken on dates. I make all the same points about if there had been any issue with actually narrowing this down, it could have been dealt with earlier. But I think that the question of breadth is probably now dealt with because the formulation of the words used is identical. So the only point I think I probably need to address, Your Honour, on is this point about possession, custody and control. I've laid it out to some extent in my skeleton, but as framed in my learned friend's skeleton, he says that Mr. Shehata was a shareholder of Health Insights Egypt and was a director until June 2022. So either he might be privy to documents or he could request...
Just repeat that. I was turning the page and didn't catch what you said.
Yes. My understanding is the point advanced is that Mr. Shehata is a shareholder of Health Insights Egypt and he was a director until June 2022. So either he might be privy to those documents already, or he could request them from the company is the point taken about possession, custody and control.
And it's that he has got...
he in his capacity as shareholder could ask for them, I think is really the point. And we say that's
a shareholder can't, can he?
Well, precisely. We say it's misconceived at a number of levels because, of course, he was removed from his position as a director during 2022. So, insofar as he previously had access to documents, he clearly doesn't, having regard to his removal. So, he can't say in his capacity as a director he has access to this information. As it relates to his position as a shareholder, it's just simply not the case that shareholders are privy to company documents. That misunderstands the rights of shareholders. I mean, generally speaking, shareholders have got pretty limited rights to inspect company documents and are provided the example particularly of DIFC company law, where there is express provision in the company regulations which say that shareholders do not have a right of access to company documents. And there are generally limited carve-outs in the company's law regime, both in the DIFC and in England and Wales, which set out the limited categories of documents which a shareholder could inspect. And in my skeleton,
I assume this company is incorporated in Egypt, is it?
It is, and there is no evidence that's been introduced that says that Egyptian law is any different. Your Honour, we would say, in the absence of evidence, one would apply a presumption of similarity to DIFC law, which would be no right of access to company documents. And where that leaves one is if the only capacity in which Mr. Shehata can act in respect of Health Insights Egypt is in his capacity as a shareholder, when one looks at the test laid out in Part 28 RDC, so it's 2817, which is the provision says that you have to state that the documents are in the party who's the recipient of the request, that it's in their possession and custody and control, and also you confirm two things: either that it's not in your possession, custody, or control, or that it would not be unduly burdensome for you to get hold of the documents.
Has Mr. Shehata done that?
Well, we requested the documents in the context of this litigation, and the answer was no. The people involved in dealing with the request in both instances are the same. So at the end of the day, it's the claimants who are processing the request and deciding whether, in the context of the hostile litigation that they have with Mr. Shehata, whether they're going to provide the documents. And the point we make really is that if they're saying no in the context of this litigation, sending a letter is going to achieve the same net result, which is a response which says no. But in any event, on the application of the test under Rule 2817, does Mr. Shehata have control in the sense of having either a legal right or an arrangement or understanding through which he can access the documents in his capacity as shareholder? The answer is no. And so the request is one which is properly made on that basis.
All right. Mr. Jackson.
Thank you, Your Honour. As I said at the outset, we've objected to this request on two bases. In terms of the breadth objection, I agree with my learned friend that substantially the same points apply as for request one. So I don't propose to address Your Honour further on that. Safe to say that if Your Honour is minded to make a document production order in relation to this request, in my submission, it should be understood in the same way as request one, insofar as it uses the word management.
Yes.
In terms of the possession, custody, and control point, the argument that's been put on behalf of the first defendant, I think, slightly misunderstands what we say on this. So the point which was made by my learned friend is that we were wrong to suggest that a shareholder has a right, I think was the thrust of his submission, to obtain documents. But that's not quite how we put the point. If I could take Your Honour to Ms. Roshan's third witness statement. This is at Bundle C, tab 3, page 192.
What paragraph?
Paragraph 32. And you'll see, Your Honour, at 32 sub 1, what Ms. Roshan says is, I understand from the claimants that Mr. Shehata has been a shareholder of HI Egypt since its incorporation, and he was also a director of HI Egypt until June 2022. In fact, my instructions are that he was the CEO of HI Egypt in his capacity as director. Now, the point we make is a straightforward factual one, which is that given that the first defendant has always been a shareholder and was a director of the Egyptian entity until June 2022, he is very likely to have documents within his control which demonstrate what the ownership of HI Egypt is.
He says he doesn't he, Mr. Jackson?
Well, his counsel says he doesn't. And this is a point I'm making in my skeleton, Your Honour, that we raised this point at paragraph 32(1) of Ms. Roshan's witness statement, and there hasn't been any evidence served in reply to that. So Your Honour doesn't have any evidence from the first defendant saying, I do not have these documents within my possession, custody and control. So in my submission, there's no evidential basis for Your Honour to make a finding that he doesn't. And he had the opportunity to serve evidence in reply and he didn't do so. And the natural inference in my submission is that he does have the documents within his control, else he would have confirmed that he didn't. So for those reasons, I say that this request should be rejected, Your Honour.
Sorry, Your Honour, it might help if I just make one very brief point in reply.
Yes.
It's about the date range. So the date range for these documents doesn't span back the lifetime of the company. It's from the 1st of January 2022. So we're looking at the period after the dispute emerges. So it's to catch documents which he doesn't have in his possession by virtue of his historic involvement in the company. It's to look forward, and that's it. Paragraph 19 of the document that was filed with the application at page 151.
So he states D1 does not possess a possession of and so on. Yes. So the point you make is a temporal one. That you want the documents from 1 January 22 until today, and he was only a director from January to June of 22.
Yes. So it's effectively for the documents for which he's effectively become unsighted.
Yeah. All right. On the 2 points of objection, so far as breadth is concerned, this is not materially different from the first request, to be understood in the same way, and I find it not too broad. So far as custody, possession and so on, the control is concerned, Mr. Shehata was only a director up until June of 22. He seeks documents from January of 22 until today. His request stated, and his counsel states, and states through his counsel, that he doesn't have the documents, and I wouldn't expect him to if he was only a director until June of 22. I will require the payments to answer that request. What's next, Mr. Doherty?
The next is request 5. This time it relates to Health Insights Saudi Arabia. So we're dealing with much the same points. There's no objection in this instance based on possession, custody, and control. I don't understand there to be any objection on the basis of relevance and materiality. Importantly, in the context of both this request and ones that we'll come to, of course, the claimants will have had the opportunity to adduce evidence in connection with this application. They could have, if, for example, Health Insights ID didn't exist, say, well, this company doesn't exist. They haven't done that. They haven't denied the existence of documents which would be responsive to this request, i.e. that they have set up a company called Health Insights in Saudi Arabia, which they own or control. And that in itself should be pretty telling as to its relevance and materiality in any event, given that the breadth issues that arise are the same as with other requests. I don't know if I need to address you in any further detail on that.
All right, Mr. Jackson, is there any relevant distinction in request 5 from 1 and 4 on breadth?
Your Honour, no, and that's the ground of objection we rely upon. So all I would say is, again, it should be understood in the same way.
Yes. Yes, it is to be understood in the same way, and on that basis should be answered. Yes, Mr. Valpady.
The next is request 7, although it's request 7, I can address all my submissions in 2 parts, because there are, in a sense, 2 aspects to it which follow on from the way that prior requests have been drafted. So request 7 is documents which show that either or both of the claimants are shareholders in any company which conducts business in the same field as, or otherwise may reasonably be construed as, a competitor to Health Insights Dubai. And the 2 strands to that are, first, its details concerning incorporation and shareholding structure of these companies. And then it's any marketing materials referring to the MCC software or details of its contracts with third parties. So the first portion of that traverses the same ground we've already looked at. So the pleaded case from the first defendant's perspective is that companies are utilizing the economic rights to the software MCC, and where monies have historically been paid to Health Insights Dubai through that economic utilization, they are no longer. And that's because the activity is being carried out by entities which are owned or controlled by the claimants, and that includes Health Insights Egypt, Health Insights Saudi, but also other entities trading as Health Insights. In relation to this request, I should note that there's been a further narrowing when it came to the breadth objection that was made after the request to produce was filed. And we made it clear that what we were narrowing this request to now was, 1, in effect, what we've looked at. So it's shareholding and management. So the trade licenses of any entities, together with details of their current shareholding and management structure, insofar as those are recorded in separate documents. And then point 2, which is maintained, which I say I might circle back to in the context of other requests, is any contracts executed by those entities relating to the MCC software. So what disappears is the reference to marketing materials.
So just say again what the second category is.
It's any contracts which have been executed by those entities. And so the next cluster of documents that we'll come to are seeking copies of contracts entered into by Al Khalij and Health Insights Egypt and Health Insights Saudi, but also any other Health Insights entities or entities trading using MCC.
So any could you spell out, if you put somewhere in writing, what the category is? If not, can you
yes
say it now so that I can make a note of it?
Yes, bear with me. It's page 154, paragraph 31. This is the application document in support of the first defendant's application for a document production order.
Any contracts executed by those entities relating to the MCC software.
Yes.
I see. Yes.
And for present purposes, what I suggest the most sensible way of dealing with this is to deal with Roman numeral 1, because it's the context we've already been looking at.
Hmm.
And then once we've dealt with the other clusters of submissions that we have about contracts requests, we come back to Roman numeral 2. But what we're seeking in respect of Roman numeral 1 is the same sets of documents we've been looking at up to now. So show us the shareholding and show us who the managers are. And what is important, we say, to note about this aspect of the request is if no other entities existed which were in effect trading under the Health Insights brand, or were trading in competition to Health Insights Dubai, it would have been very easy for either of the claimants to have put in a witness statement in answer to the application to say there are no other entities which exist, which fall within this category, and therefore there are no documents to disclose. They haven't done that.
Can I ask you, Mr. Doherty, so far as the request refers to conducting business in the same field as or may otherwise reasonably be construed as a competitor to HI Dubai, is the business of HI Dubai confined to dealings with the MCC software?
Yeah, so the business being conducted is as a partner reseller for MCC, previously Medica Plus, but now Medica Cloud Care. So the request is, as one can see, when it comes to the contracts that are being requested, we're requesting contracts relating to the MCC software. So that's the narrow scope that we're dealing with on the subject matter. Right. And so insofar as there are entities which are executing contracts which relate to the rollout to healthcare facilities of MCC, we are seeking copies of their trade licenses, shareholding structures, management structures.
Yes.
And like I say, if there are no companies which existed which were doing that, it would be very easy to put in a statement saying so. But nowhere in the evidence or even in the submissions is there a suggestion that the entities don't exist, which could be construed as a competitor in that sense. And there are certainly no assertions that no documents exist which are responsive to the request, which in my submission is not broad. It is a request for a limited category of documents, insofar as there are entities trading using Medica Cloud Care or licensing Medica Cloud Care to healthcare facilities. The relevance and materiality should be pretty clear. And if the claimants have set up companies which they own, then they should disclose the identities of the companies and the shareholding structure and the management structure.
And in broad, at a very, again, high level of generality, the materiality comes from the defendant's counterclaim includes a plea that the claimants have diverted business from HI Dubai into these other entities. Is that the essence of it?
Yes, and then there are two strands to that even. So one is diverting the revenue streams that had been generated previously by Health Insights Dubai, but then also there's the second element, which is the expansion of the rollout to new facilities, which ordinarily would have been to the benefit of Health Insights Dubai, but is now to the benefit of these other entities.
Yes. All right. All right. So that deals with the breadth and the materiality. Those two, I think those are the only objections, are they?
Yes, Your Honour. If I could deal with the point on breadth first.
Yes.
As Your Honour's seen, this request has changed over time.
Yes.
If Your Honour would just look at page 154 of the bundle,
Yes,
which
I've got that.
I'm grateful. And Your Honour can see the original formulation at the very top of the page, and then at paragraph 31 at the bottom, it is the
Yes.
revised formulation.
Right.
But in my submission, what's not clear is what the interaction, if any, is between these two parts. So as I had understood it, prior to my learned friend's oral submissions at least, what the first defendant was seeking was limited to what is stated in paragraph 31. In other words,
I'll ask Mr. Doherty to confirm that so that he didn't go around it. Is that right, Mr. Doherty? What you seek are what's set out in 31, Romans 1 and Romans 2.
Yes.
Thank you. Yes, Mr. Jackson.
That's helpful. So I understand that one doesn't need to make reference then to what's in the original request, and 31 stands on its own. And I'll make my submissions on that basis.
And I should, and I'll say, and the Doherty will tell both of us if I'm wrong. So it's not documents relating to, it is what is to be produced is the trade licenses of any entities, together with details of their current shareholding management structure, insofar as those are recorded in separate documents. And that would be of or any company which conducts its business in the same field as or otherwise may reasonably be construed as a competitor to Health Insights FZ LLC. Is that right, Mr. Doherty?
Yes, and I suppose the parameters of what we're talking about in terms of competition are, companies who are trading in using Medica Cloud Pair and rolling it out.
Yeah.
And it may well be that the precise, particularly of Roman numeral 1, and it may be that it's a discussion that Mr. Jackson and I can have, and I don't know whether there would be objection to it, but in effect, Roman numeral 1 is traversing the same ground as the requests we previously looked at. So it may well be that it makes sense to put them in the same language, but as long as there's the understanding that what we're after is, in effect, the same thing.
Yes.
Yeah. I mean, that was the point I was trying to elicit, Your Honour, and you helpfully did it for me, which is that, as I understand it from what Mr.
Always
Doherty,
pleased to be of service, Mr. Jackson.
I'm very grateful. As I understand what Mr. Doherty said, one does need to read in his submission the revised formulation of the request with the original, in the sense that one has to read any entities in Roman numeral 1 as any company which conducts business in the same field, etc. So I'll make my submissions on that basis.
Yes.
I do say that this request is very different to the ones that we looked at on the requests 1, 4, and 5 in terms of its breadth. And there are a number of aspects to that. If we can start with Roman numeral 1, obviously I don't take a point that the word trade licenses is too broad. One can understand that. The problem with Roman numeral 1 comes with the phrase any entities, and the words that Mr. Doherty submits have to be read into that, which are contained in the original formulation of the request.
So to be clear, Mr. Jackson, I understand the formulation now to be any entities which conduct business in the same field as or may otherwise reasonably be construed as a competitor to Health Insights FZ LLC.
Yes, that's very helpful, Your Honour. That's how I understand Mr. Doherty to put it. The reason that's problematic is because whether a company conducts business in the same field as, or a fortiori may reasonably be construed as a competitor to HI Dubai involves a highly subjective assessment. Now, HI Dubai is, it's fair to say, a software company. Its principal product is MCC. But it's certainly not clear on the face of this request how a document reviewer would assess what is to be construed as a competitor to HI Dubai. And one can imagine the problems that would be caused while seeking.
I want to stop you there, Mr. Jackson. You said, I think you formulated as HI Dubai's, I think you said main or principal business is MCC software. I thought that was its only business. It may be a distinction.
There may be a distinction, Your Honour, as a matter of fact, but I don't think it affects the point that I'm making in the breadth of the request, which is that it's a difficult subjective exercise for the reviewer to determine, well, what is a company which conducts business in the same field as, or
well,
otherwise.
It depends, doesn't it, Mr. Jackson, how broad or narrow that field is. If you have a business which if you have a very diversified business that conducts all manner of manufacture, retailing, and so on, that may well be a problem. But when you've got such a narrow business as this, which, as I understand it, is what's the expression, partnering and reselling, or put at its widest, licensing and making available MCC software, that seems a particularly narrow business, and I have for the moment difficulty seeing how there could be any difficulty in deciding whether you're in that competing with that business or not.
Well, the partner reselling is it's the arrangement that the first defendant says existed as a matter of fact. So it says that, or rather he says, that he was the original creator of MCC.
Yeah.
He then licensed that to the third defendant, HI Malaysia, who then engaged the second defendant to act as a partner reseller. We don't accept that on our case. So, but in terms of what HI Dubai was doing, I mean, there are a number of ways in which its business could be construed. On the one hand, one could say, well, HI Dubai is a software or technology company, and that's the field in which it operates. One could then adopt.
It doesn't make games or any other software. It's very specific, isn't it? It's confined to this hospital management systems, more specifically M+ and then MCC. At its widest, I would have thought it was maybe some software developed from those, although there's no suggestion on any of the papers I've seen that there's some other version of the software. Its business seems to be confined now to, at the very widest, dealing with MCC software, which is a very specific software, isn't it?
Well, MCC is a software, but it has a number of different components to it.
Right.
There was also a predecessor to MCC called M+.
Yes.
And while Roman numeral 2 relates specifically to MCC, Roman numeral 1 doesn't. So that's the potential cause of difficulty. But on the first point Your Honour made as to its business being specific, my response to that is that Roman numeral 1 doesn't tie it down specifically. And in particular, the words or otherwise may reasonably be construed as a competitor to HI Dubai are problematic, because what that means is wherever it's reasonable for the document reviewer to construe another company as a competitor, then the documents have to be produced. And that is a much broader assessment that could take place than simply saying.
What's the difference? Can you illustrate to me how may otherwise be construed as a competitor in this case may be wider than conducting business in the same field? So I don't mean that at some theoretical level, but in this case.
Yes. So the person reviewing the documents will sit down and let's say, for example, they have an entity which is a technology company but does not provide hospital information management systems, as HI Dubai does. And the issue is whether they have to disclose or whether the documents relating to that entity have to be produced, because at least on one view, the language or otherwise may reasonably be construed as a competitor could capture that sort of entity.
Well, I have difficulty understanding, Mr. Jackson, I mentioned I don't know, if they produce software that's got nothing to do with hospital or health management, they got software that's got something to do with football analysis or something. I don't see how it could be construed as being a competitor.
Well, I accept, Your Honour, that there may be shades of grey in terms of the type of the type of precise business that the other entity would be engaged in. But my simple point is this doesn't tie specifically down to hospital information management system, and therefore it is broad. The other point I'd make in terms of the breadth is in terms of the entities, that because there aren't any specific entities identified by name, and one presumes that these are entities which the first defendant wants to say the claimant's own but hasn't identified. That is another source of breadth, because there aren't any jurisdictional constraints in Roman numeral 1. These could be entities in any jurisdiction, yes. Nor is there any date range that's been proposed by the first defendant in relation to this request. And what that means is these trade licenses and these contracts would relate to any period in time. That's perhaps less problematic as regards Roman numeral 2, because MCC was developed from, I think the evidence is around 2016 onwards, although that's still a significant period of time. But it's particularly problematic with Roman numeral 1, because what Your Honour is being asked to approve is a request whereby the claimants have to search from the very start of time to the present. In terms of the other part of Roman numeral 1, the wording details of their current shareholding and management structure, that is not a document or category of documents at all. What that is a request for information. Now, information can obviously be contained in documents, but one has to specify a category of documents that's being sought, and that doesn't do so. So my submission, Roman numeral 1 should be rejected for those reasons. In terms of Roman numeral 2, any contracts executed by those entities relating to the MCC software, again, I make the point on the date range. As I say, for the purposes of this aspect of the request, it's likely to be from around 2016 onwards, because the first defendant's evidence is, at least on his case, that MCC was developed from around that time onwards. But the real problem is that in relation to the contracts and the counterparties, contracts are not identified by date, nor are there any counterparties identified, either by name or even by category of counterparty. So Roman numeral 2, for those reasons, is again a very broad request. Now, that deals with breadth and proportionality. In terms of the relevance and materiality of the request, just to respond to some of the points my learned friend made, as I understand it, what the first defendant says in relation to this is, well, we need details of these entities, whoever they might be, because we understand that there has been a diversion of business to them. If I could just show Your Honour the first defendant's pleaded case on this. So if Your Honour goes to the defence and counterclaim, which is Bundle A, tab 4, and the specific paragraph that I'd invite Your Honour to look at is paragraph 68, first of all.
And what page is that on?
That's page 33. Apologies.
Yes.
So paragraph 68, there's a general plea that hospitals which have entered into contracts with Alkalij and or other entities owned or controlled by the claimants continue to use the MCC software. And then there's a reference to Al-Khalij and an excerpt from its website. Now, we disagree with the construction of that particular screenshot or quote from Al-Khalij's website, because what it's actually doing in our submission is quoting an extract from HI or Health Insights itself. But for present purposes, the point is only Al-Khalij is referenced with any particularity at all in the second sentence. The other entities aren't mentioned. Then one looks at paragraph 69, which says the claimants, through other entities owned or controlled by them, have also sought to expand the number of hospitals. And there's reference to various, or to a Facebook page, and also to an email from the second claimant to employees of the second defendant. But one, again, doesn't get any particularity on who these entities are. At paragraph 70, it said that while the full extent of the claimant's activities are unknown, it is understood that the number of sites in which MCC has been implemented has increased, but no particulars are provided of where that understanding emanates from or what it's based on. And then at paragraph 72, there's an estimate, the explanation for which isn't provided, as to revenue having been diverted from the second defendant, and it's said to be £6.5 million per year in respect of existing hospitals. $6.5 million a year, and $23.5 million in respect of new facilities, but there's no explanation as to how that's been come up with. And then at paragraph 73, it's again said it is understood that revenues generated essentially from MCC have been retained by Al-Khalij and or diverted to entities owned or controlled by the claimants, including but not limited to Health Insights Egypt, Health Insights Saudi. So the only three companies that are specifically identified in the alleged diversion of business, and we don't accept any business was diverted to them, but the only three companies that D1 identifies are Al-Khalij, HI Egypt, and HI Saudi. And the other entities are not named, and there is no particularized plea as to why those entities, are unidentified as they are said to be the recipients of diversion of business. Now, in our reply and defence to counterclaim, a lot of what we say in response to this allegation is that it's not properly particularised. And that's an entirely proper plea for us to make. My learned friend says, well, the claimants haven't denied that these entities exist. We deny that there was any diversion of revenue from D2 whatsoever, and that is expressly pleaded. But our case is that the first defendant has not pleaded a properly particularised case that revenue was diverted to these unidentified subsidiaries. So for those reasons, Your Honour, I say there isn't a sufficient pleaded basis to grant request 7, because what the first defendant hasn't done is spell out who these entities are that it alleges revenue was diverted to, or even the basis for his alleged understanding that revenue was diverted to them. And in the absence of a pleading satisfying either of those elements, I say that Your Honour should dismiss this request.
Your Honour, I may have a few points in reply. One is what I was going to suggest is that when we deal with Roman numeral 2, we circle back to it after I've dealt with requests 2 and 6, because there are underlying documents which I was going to show Your Honour, which frame some of the context in which this request is made.
All right.
But I suppose the simple point in response to Mr. Jackson has just said, which is that we haven't specifically identified, if funds are being diverted from Health Insights Dubai, the claimants aren't exactly going to offer up the names of the companies that they're diverting it to. There's always going to, in these sorts of requests, be an element of unknown, in that we don't know the name of the specific entity. But what has been pleaded is that there's been a diversion to entities which the claimants control, including but not limited to Health Insights Egypt and Health Insights Saudi Arabia. The assertion has been put that these entities exist, and as I said at the outset, it could have very easily have been denied in a witness statement in response to these applications. none of these entities exist in competition. There are no other entities trading as Health Insights Dubai or trading in MCC. There are no contracts. Again, very easy evidence to provide, which has not been provided, which one can clearly read into that a strong inference as to why these documents are being requested in the first place. And insofar as it comes to proper particularization, it's not unusual in cases like this, following disclosure, for consequential amendments to be made once the documents have actually been provided. But if I can park the contracts aspect of it just for the moment and deal with the companies themselves, and I'll deal with it very briefly.
All
But
right,
it's-
Mr. Doherty, whilst you're doing that, can you remind me on what page I find your revised request? It's got Romans 1 and 2 on it.
Sorry, yes, I think it was 154.
Yes, it is. Thank you.
Is Your Honour content to deal with Roman numeral
Yes.
1 now, and then we'll come back? Okay. So it says trade licenses of any entities, together with details of their current shareholding and management structure. I note that a few different points seem to have been taken on breadth. Insofar as those are considered to be issues, the cut through on Roman numeral 1 would simply be to reframe it so that it's in the same language as requests number 1, 4, and so on that we've already looked at, which would make it clear in that context that what's being sought is, and one can refer to trade licenses. Not all jurisdictions have a document called a trade license per se. The types of documents that exist can vary from jurisdiction to jurisdiction. So it might simply be more sensible to say, as we have in respect of other requests, documents relating to the ownership and management of entities trading in competition too. And similarly, if it helps in reducing any amount of confusion, I'm sure that one can put in brackets what is meant by competitor, i.e. what we're really getting at here is operating in the field of licensing, selling, maintaining, implementing healthcare management software, and that should not be particularly difficult for anyone to identify. And really, these are the sort of simple points. Stepping back from that, it's important to remember what's being requested. This isn't a document that's buried away in the corner of an office, or something that can slip down the back of a sofa and be forgotten about. We're talking about the claimants setting up companies. We're talking about information that ought to be readily knowable to them. And the submissions put forward by my learned friend about this being a difficult subjective exercise for a document reviewer somewhat takes away the necessary agency from the claimants, who ought to be, at the end of the day, signing a document production statement on this, which is, if they have set up a company which is trading in medical software, or even companies which are trading under the Health Insights brand, they're obviously going to know about that, and therefore they're going to know where to look for those documents. This isn't some blind exercise to be conducted by a document reviewer. Insofar as there's said to be any ambiguity about whether one should be seen as being in competition with Health Insights Dubai, again, that's something that the claimants themselves ought to be acutely aware of as directors of Health Insights Dubai. They should know, is this company which I'm setting up reasonably in competition with another company of which I'm already a director? And if at the end of the day, the answer is that, well, actually, we might not have put the evidence in, but these documents don't exist, the appropriate course to adopt would be to make the request, given the inferences that we can currently draw. And if that's the answer, then the claimants can justify that by explaining the search that they've carried out and signing under a statement of truth a document production statement which confirms these entities don't exist. And if necessary, they can be cross-examined about that at trial. But based on the current state of evidence and based on this slightly odd fact that the claimants have not denied the existence of these companies, then the order should be made.
Mr. Doherty, there should be a date range, should there not?
Yes, I suppose in this case, obviously one doesn't know precisely when a company is formed, but one in the way our case is put, which is that these are companies are set up which are continuing to use it. I suppose one could use the same timeframes we've used previously. So, for example, from 2016,
Yes.
which would make it no broader, rather than it being in perpetuity. Yes, I think that would be sensible, and I think that would capture relevant entities.
All right. So where the revised formulation has now got to is that first there will be a date range, which was at 1 January 2016 to the present. Secondly, it will be reformulated by relating to, in terms of documents relating to the ownership and management of those companies. Thirdly, there will be some specifying of the same business as or otherwise may reasonably be construed as competitor to Health Insights FZ LLC. Is that last point correct, Mr. Doherty? You were offering words to the effect that I think in the business of, and I forget exactly how you put it.
What one could say, licensing, selling, maintaining, or implementing healthcare management systems or software.
Yes.
To that effect.
Yes. All right. Well, in my view, that's sufficiently focused, and I will require a request in those terms. You will, of course, have to put the precise wording and confer with Mr. Jackson to ensure that the precise wording that you adopt meets what we have spoken of today.
Thank you.
Sorry, just before we go on to that, because I didn't address you on the reformulation of the business.
All right.
I'm sure it's something Mr. Doherty and I can seek to agree between us. For our part, I think what we would prefer is a formulation which accords with the approach Rene suggested earlier, specifying what services are being provided. What I would suggest is the provision of hospital information management systems, something along those lines. But I just wanted to.
I think that's right, isn't it, Mr. Doherty? That's from what I've understood. The business of HR Dubai is confined to that.
Yes, I think we're getting at the same thing, but I suspect either I'll put the language to Mr. Jackson, and it may well be that we agree. If we have slightly different formulations, I imagine what will happen is we'll do a draft order and tell you what the different formulations are, and Your Honour can choose one.
Yes.
I'm grateful.
The next set of requests are in relation to contracts. So this is request 2, 6, and then 7, Roman numeral 2. So that is contracts entered into by entities owned and controlled by the claimants for the provision of hospital management systems, in effect. And the factual context around this in the pleadings is page 22 and paragraph 20. Which is the pleaded case as to how these contracts were previously entered into. So in the first defendant's pleaded case is that you have MCC, which is licensed to Health Insights Dubai under a licensing agreement. Health Insights Dubai is a certified partner reseller for MCC, which permits it to, in effect, sub-license and utilize economic rights within the UAE, Saudi Arabia. And that as part of that, Health Insights Dubai conducted business with Al Khalij, and that's the section of the pleadings which I took your honour to earlier when we were looking at the pleas with respect to ownership and management of that entity. So that was paragraph 56 onwards from page 31. So
Yes.
that was paragraph 58, which says that Al Khalij then acts as a distributor of Medica Plus and the MCC software within KSA, and that was from the 6th of January 2015. So the first defendant's case is, as I alluded to earlier, twofold. One is that where you had contracts that were previously executed by third parties and revenues had been payable to Health Insights Dubai, those revenues stopped in 2022. Well, they stopped completely in 2022. There had been missed payments from 2020. And those are then diverted to entities other than Health Insights Dubai. And the second part of it is that there is an expansion of the rollout of that system in further hospitals. So new contracts being entered into, circumventing Health Insights Dubai's role as the licensed partner reseller. So the business is in effect being transacted by Al Khalij with other entities trading as Health Insights, and presumably they're then getting the revenue. And for your note, the partner reseller agreement is at page 473 of the bundle. So there are, the way the requests are formulated are in effect, there are two sides to it. One, there is the contracts that Al Khalij are entering into with hospitals, essentially, so healthcare facilities, for which they're obtaining revenue, which historically some of that would have passed on to Health Insights Dubai. And then there's the other part, which is the receiving entity, which is now replaced Health Insights Dubai. So that's Health Insights Egypt, Health Insights Saudi Arabia, and these other entities we've been discussing in the context of request number 7. Request 2 is the Al Khalij side of it. So it's contracts held by the claimants in relation to Al Khalij's sale and or licensing and or support services in relation to Medica Plus or Medica Cloud Care entered into with hospitals or healthcare providers or government ministries or entities in the Kingdom of Saudi Arabia. And the basis of that is we have evidence historically, but also after this dispute began, showing that Al Khalij is utilizing MCC in healthcare facilities. So looking at the historic position at page 553 of the bundle, this is just, there are other ways of showing this, but this is a relatively simple one. These are Health Insights Dubai's bank statements, which show the inward transfer of money that's due from Al Khalij for its own distribution of these systems. And you can skim through the bank statements, and they're highlighted in yellow is these series of payments which are being made. So this starts in September 2020 and carries forward, and they relate to specific invoices. Some examples of those invoices can be seen at 638. And this is an example of an Al Khalij generated document from August 2020.
Now 638, I have an order. There seem to be multiple numbers on these. Wait a minute, I'm looking at the download. At a download, I'll go back to the live bundle, see if that is any different.
There's an issue with the printing on the pages in that I think it's been double stamped from being used in the court system before. I'm working off the PDF of at least what my understanding the latest version of the bundle is, and I'm looking at page 638, which is
638 you've got.
which should hopefully in the electronic bundle be a document on Al-Khalij headed paper.
You're going to have to bear with me. I've been looking at a downloaded version. I've now got onto the online version, and as always, it's taking a while for it to come up. So we'll have to.
I'm happy to
patience.
describe while it waits, but I will wait for it to come up in general. But it's a
What is it? Yeah, just tell me.
It's an Al-Khalij headed paper. It's addressed to Mr. Shehata in his capacity as the Chief Executive of Health Insights, and it describes a $5 million payment in respect of Medica Cloud Care Hospital and Clinical Information System support and maintenance for 23 hospitals from the 18th of March 2020 to the 17th of March 2021. So it's the purpose of the document is to show Al-Khalij has plainly got contractual arrangements with, amongst other things, these 23 hospitals, which they are providing, they're rolling out MCC to, and they're therefore paying Health Insights Dubai. And then you might wish to try, it may not work as well, but page 644 is an example of the other side of the equation, which is the tax invoice issued by Health Insights Dubai. The same period. So it's 644. I don't know if that brings up a misaligned document or not.
It's got a tax invoice at 644.
Yes.
I've got a tax invoice.
Yes, that should be the one. So on
number
the top
56
left-hand side
of 2020.
Yes, correct. So the top left-hand side, we can see that the document is issued by Health Insights Dubai because it specifically says Health Insights FZ LLC, which is the legal name of the Dubai entity. On the top right, it also gives the address for the Dubai entity. And we have the reference to the corresponding amount of the Al-Khalij invoice. So it's the maintenance for the 23 hospitals from the 18th of March 2020 to the 17th of March 2021 for $5 million. So that's the historic position. Health Insights Dubai have a contract with Al-Khalij. Al-Khalij have a contract with their hospitals, and the payment flows in that way through to the Dubai entity. What we also have is access to information showing at least one limb of the diversion of those amounts. So 1861 of the bundle you should hopefully find an extract of a legal translation from a judgment.
Yes.
And this is a case in the Riyadh Commercial Court between, so it's a claim brought by Health Insights Dubai against Al-Khalij for payment of unpaid invoices. And at 1861 is the argument that is in effect being put forward by Al-Khalij, who, of course, in the defendant's case are controlled by the claimants. And what they say is that the plaintiff claims it is contracted with my client and attached several enclosures to its claim, and this is completely incorrect. The truth is that the client contracted with Health Insights Egypt Cairo and did not contract with Health Insights Dubai, and each of the two companies is different from each other. So their position is, well, we're not paying Health Insights Dubai because the money is owed to Health Insights Egypt. Now, that's obviously at odds with how payments have historically been made, but is also at odds with the invoice I've just taken you to, which shows that it is the Dubai entity that is due the payment. And then at 1735,
Yes.
one can see what I would term as the ongoing diversion of the income. So this isn't just about the historic invoices, this is about new invoices. So it's a translation, but you can see that the recipient name in the middle of the page, so this is a payment being requested from Al-Khalij. And King Fahd, I think, is a reference to a King Fahd medical facility, and we see the amount is $480,000. And then the issuer, where there's a black line at the top half of the page, it says taxpayer name, Health Insights for software design. So that's Health Insights Egypt.
Yes.
So on the first defendant's pleaded case, both the historic sums which were being claimed in the Riyadh courts, but also ongoing business, appears to be being diverted amongst other entities, we say, to Health Insights Egypt. So the Al-Khalij payments traditionally made to the Dubai entity are now going to the Egyptian entity, which the claimants have control of. So when it comes to relevance and materiality of some of these underlying contracts, one can quite clearly see how it fits in to the pleaded case. Now, as I understand the way the claimants put it, they're saying that the request being made for a contract is unduly broad and disproportionate, and that it lacks relevance and materiality. If I could deal with the relevance and materiality aspect of it, first of all, if Al-Khalij, who had historically been making payments to Health Insights Dubai, have stopped and instead are making those payments to someone else, that's quite clearly relevant to the pleaded case. This is all about diversion of income. And part of demonstrating that that is happening is, of course, looking at what Al-Khalij's trading activity is. Because if it's continuing to offer, pursuant to the terms of contract, these 23 hospitals, MCC as a implemented, maintained service, and if it is also going to market in Saudi Arabia and expanding the number of healthcare facilities which it's offering to, the entity who has a right to receive payments in respect of that should be Health Insights Dubai. So if we've gone from 23 hospitals to 30 hospitals, the additional 7 hospitals should have the income received by Al-Khalij, a portion of that should have gone to Health Insights Dubai as the partner reseller. When a point is taken about relevance and materiality, as high as it seems to be put, I think, is that not all contracts could be relevant for the purposes of this case. So it doesn't necessarily seem to be an assertion that there is no general relevance or materiality. It seems to be more about whether this should be more focused on a narrower date range. Now, we say that that approach can't be right because in order to show diversion of income, there are two sides that one needs to look at. So yes, one could say that if there have been contracts entered into, for example, after the 1st of January 2022, which are in respect of healthcare facilities for which Health Insights Dubai is not getting paid, those contracts are relevant to the income that has been diverted. That's correct, but one also needs to see what and establish what had gone on before to show that that is a diversion of income. So the historic position of how contracts were entered into by Al-Khalij is relevant in informing whether or not there is a change which arose as a consequence of this dispute, which meant that contracts for which Health Insights Dubai had historically generated revenue, it is no longer generating revenue from. And that's why we say that the narrowing of the date range in the way that I understand the claimants to be suggesting is not appropriate.
Well, how far back do you say they need to go?
Yes, I believe that this is from 2015. It relates to MCC, which of course only exists from 2015, 2016 onwards. And so we're necessarily talking about a confined period of time.
So again, there's 2016, 1st January 2016 onwards.
It's 1st of January 2015 onwards.
1st January 2015. That's when MCC was rolled out, is it?
It's when it was created. It seems as though there's a time lag. So, for example, if one is looking just at these invoices, you can see from around 2017, 2018 onwards, there's a shift in the description from Medica Plus to Medica Cloud Care.
Right.
So in reality, some of them might be after that, but in order to ensure that we're catching everything that could possibly relate to MCC, it would be from the 1st of January 2015. And really the point of distinction between us seems to be whether it should just be forward-looking or whether it should be forward and backward-looking. And I think I've given you my reasons for that, which are to show the position before and then to show the position afterwards. The other criticism that's then made is that this is a broad and unfocused request. And respectfully, just because there can be a large amount of relevant and highly material documents doesn't mean that it's broad or unfocused. So if there are contracts for the rolling out of MCC, those are relevant and material to this dispute, irrespective of whether there are 10 contracts or whether there are 1,000 contracts, because on our analysis, all of the income that's generated, some of that should be passing to Health Insights to buy. To the extent that we're criticised for not specifying the names of the facilities, again, we say that's a fairly hollow criticism because, of course, insofar as the claimants are the parties in control of Al-Khalij, they are the party who has access to information with which healthcare facilities they have contracted with. We don't possess all of that information, and it's one of the reasons why we're, of course, making the request for documents in the first place. But to address the criticism even more head-on than that, the case has been put as clearly as it and as specifically as it possibly can from the first defendant's perspective in the pleadings. So, for example, page 33, going to the pleadings.
Yes.
That's out the factual basis on which it's understood that there is an expansion of the number of facilities and that there is continued trading using MCC. So paragraph 69A refers to a communication from January 2022 from the second claimant writing to employees of the second defendant, stating that the company has further acquired contracts for the provision of MCC to 3 new hospitals. And the second is the Health Insights Group Facebook page, which makes reference to the integration of Medica Cloud Care software in hospitals in Saudi Arabia as recently as the 27th of July 2024. So these are new instances of implementation. And then at page 62,
yes,
there is a setting out then of the contracts which are reasonably believed to exist based on the available information to the first defendant. So paragraph 12 at the bottom of the page deals with contracts in respect of Medica Plus. And then at page 65, paragraph 13,
yes,
refer to the basis for thinking that the support contract exists for medical cloud care. So it's support and maintenance for 23 hospitals, for the King Fahd Specialist Hospital, for the King Salman Specialist Hospital, for KJO hospitals. There's work for the Ministry of Health. That's its Roman numeral. That's at point E. And then these contracts appear to roll over and repeat. So again, this isn't some kind of shot in the dark. The next point we make is to say that the claimants themselves ought to be in a position to identify and therefore construct a search for these documents. And what I mean by that is that the claimants are aware, based on the evidence we have, of who these Al-Khalij contracts are with. So one, the invoices that Al-Khalij provide, or the remittances they provide, often will state the name of the facility. So for example, that's why we get these references to the 23 hospitals. It's why we get these references to the King Salman Hospital and so on. So you would be able to identify the source of the contractual relationship simply by looking at your invoices in the first instance and then working out where the contracts are. We also have the fact that the second claimant is the business development manager for Al-Khalij. If you go to page 519,
Yes.
It's a chain of emails. So if you go to the bottom of the chain, which is over the page at 520,
Yes.
the second claimant writes from his alkhalij.net email address, please send me the invoice for the KJO project. And then over the page, we get the response, which comes back in Arabic. But the broader point here is that the second claimant, from both his Al-Khalij address and also his Hotmail address, is involved in invoicing in respect of these specific projects and can therefore be taken to know which particular facilities have been contracted with. And the same then goes for the first claimant if we go to 1668.
Yes.
Which is a WhatsApp exchange. This is November 2021. We can see the first claimant at the top, who's writing in English, is talking about the different projects, some of which correspond to the invoices we've been looking at and the pleaded points we've been looking at. The 23 hospital project, the KSSH project, the KJO project, and so on. So the claimants are not coming to us and saying, well, these documents don't exist. They obviously know that they exist. They're talking about them in these historic communications. If after this fallout had happened, Al-Khalij had simply dropped its hands and said, we're not going to trade using MCC anymore, they could have said that. They could have said that we've cancelled all of our contracts with hospitals, but quite clearly they haven't done that. We know from the ongoing invoices that they're continuing to provide those services and that they appear to be paying, at the very least, Health Insights Egypt in respect of the continued rollout and maintenance of the software. They haven't denied the assertions made about the expansion into other hospitals. So one can reasonably assume that there has been such an expansion. And if there has been, then that's relevant and material. And the contracts showing that expansion should be disclosed because they're relevant to the diversion of income. So what we, of course, have is a clear evidential basis on which to say that Health Insights Dubai, who had historically been the benefactor of payments in respect of these different projects, is no longer. So it is quite difficult to see on what credible basis you could deny the relevance and materiality and also the proportionality of this request. It's in effect central to the case about diversion of income. And there is, based on the evidence available, clear support in the documents to suggest that these documents exist. and that they're relevant in dispute. So we seek an order in the terms drafted.
Mr. Jackson?
Your Honour, we oppose this request on two bases. First, in terms of the breadth and proportionality, and second, in terms of relevance and materiality. If I can start with breadth, there are 2 points that I make in relation to that. The first point relates to the language of the request, and I say that is too broad in a number of respects. First of all, the contracts that are referred to in the language of the request are not identified by reference to date. And secondly, in terms of the counterparty.
Well, Mr. Jackson, I want to stop you there. I'm going to, I'm not sure whether Mr. Doherty conceded this, but I now take the, or I'm going to make the request one from the 1st of January 2015 to date.
Well, Your Honour, were you talking about request 2 there?
Yes.
Yes, so the date range that's been proposed by D1 is 1st of January 2015 to date.
Yes. Yes.
That's always been the position in respect of request 2.
Oh, I see. All right.
But in terms of the wording, as I mentioned a moment ago, I say that the language of contracts is too broad in the sense that it doesn't identify specific contracts by date. And linked to that, the alleged counterparties, which are referred to as hospitals and or healthcare providers and or government ministries or entities in Saudi Arabia, are not identified by name. And when one takes into account the date range that's being proposed, which is a period of over 10 years, what this requires is a very extensive search in relation to any essentially distribution of Medica Plus or Medica Cloud Care. Now, what my learned friend says, as he said in his oral submissions, is, well, D1 doesn't have specific knowledge of the contracts that Al-Khalij entered into and therefore can't identify them. And that's a point he takes in his skeleton too. Now, in my submission, that isn't correct, and it's not correct for 2 reasons. First of all, D1, its common ground, was the general manager of the Dubai entity, HI Dubai, until at least May 2023. And during that period, if the first defendant's case is that Al-Khalij was essentially acting as a partner reseller of HI Dubai, D1 must know what contracts Al-Khalij entered into at least up until May 2023. And that is a good 8 years out of the period.
Can you just explain that to me again? D1 was the general manager of HI Dubai.
Yes.
So you're saying that he would have known of contracts entered into between HI Dubai and Al-Khalij. Is that what you're saying?
No, that's not quite it, Ron. So as I understand D1's case, what D1 says is HI Dubai was essentially licensing Al-Khalij to act as a distributor to distribute M Plus and MCC.
Yes.
And what would happen would be that Al-Khalij would account to D1 for the revenues that it produced via that distribution. So that's what I understand their case.
Or should have.
Or should have. I mean, that's their case. We don't accept that that was the arrangement as a matter of fact, and we've pleaded our case on that. I can take you to it if need be later. But that's D1's case. Now, if that's correct, then D1 in his capacity as the general manager of D2, up until at least May 2023, is very likely to have been aware of the contracts that Al-Khalij was entered into, which on D1's case, he says, it was required to account to D2 for. So we don't accept that he doesn't have any relevant knowledge of what contracts would be entered into. And that's relevant to the breadth of the request, because we say it's something that should have been spelled out in the request to give it proper particularity. And that's, in my submission, supported by what D1 says in his pleading. Now, if I could take Your Honour back to D1's reply to defence to counterclaim, which Mr. Doherty took you to earlier. It's at Bondelay tab 6, and I'm looking at page 62.
Yes.
And it's paragraphs 12 and 13, which Mr. Doherty referred to, where a number of contracts are listed out. And they're said to be contracts between a succession of support contracts that D2 entered into with Al-Khalij in respect of support and maintenance for both M-Plus and MCC. So on its face there, it's talking about contracts between D2 and Al-Khalij. And Your Honour can see that in the sub-paragraphs below, there are specific hospitals identified on a number of occasions. So at subparagraph B on page 63, we have the King Abdullah Medical City, subparagraph C, Daman Regional Laboratory, subparagraph E, King Abdullah Medical City mentioned again, the same for subparagraph F and J, and then K is something called KJO, and it goes on. I won't go through all of them, but there are a large number of specific hospitals identified. And then if one looks at paragraph 13 on page 65, this relates to MCC. And at subparagraph B, it said, for example, that there was a support contract for King Fahd Specialist Hospital. Subparagraph C is King Salman Specialist Hospital. Subparagraph D, KJO hospitals, etc., etc. Again, I won't go through all of them. Then if Your Honour looks at paragraph 17 of Malone and Friends pleading, which is on page 67, this is in response to a criticism that we made that the alleged hospitals that had entered into contracts with Al-Khalij hadn't been properly particularised. And what's pleaded there is that the hospitals which have entered into contracts with Al-Khalij and or other entities owned or controlled by the claimants are those listed in the various support contracts described above. So the first defendant's own case is that...
They do add further, Mr. Jackson, they do go on to say, pending disclosure, the first defendant is unable to plead further.
They do, but that has to be borne in mind in the context of the allegation that's being made. What is being said by D1 is you have diverted business. We said you haven't specified the hospitals and the contracts which are alleged to have been the vehicle for the diversion of business to Al-Khalij. And in response, what they've done is to specify those particular contracts as the ones that they rely upon. Now, the reason that's important is because the allegation that's being made is a serious one. It's being alleged that revenues have been improperly diverted, and that requires proper particularisation based on the evidence they have. And when one comes back to the request, what Your Honour doesn't find is a specific list of hospitals, as you saw in paragraphs 12 and 13 of D1's pleading, saying these are the hospitals in respect to which we want disclosure. It's much, much broader than that.
But they don't know the hospitals that Al-Khalij has entered into subsequently, do they? They've said that there was a development, I think post 2019 or 20 was it, when Al-Khalij expanded into more hospitals. They don't know what they are.
Well, this is the problem with their pleaded case, Your Honour, that they're not...
how can they know?
Sorry, I don't know what that interruption was.
I think Mr. Doherty was saying not to sotto voce, in effect. We don't know.
I don't think it was Mr. Doherty, in fairness to him.
Wasn't
But in any event, as I say, Your Honour, this is the problem with their pleaded case, that it's alleged that there is a diversion of revenue to Al-Khalij. What's not identified is when that diversion is alleged to have taken place and how the first defendant understands it to have taken place. And what Your Honour has is a broad date range over a 10-year period, saying essentially that the first defendant should be provided with all contracts entered into by Al-Khalij without reference to any specific date where it said that there had been some change. And what Mr. Doherty wants is all of the contracts relating to MCC with any healthcare entity or hospital over a 10-year period. He's not saying
that Al-Khalij entered into.
Sorry, that Al-Khalij entered into with any government ministry or entity or hospital. It's not being said that as at 2021 things changed, there was a diversion of business, and therefore we need documents from that point onwards.
Well, Mr. Doherty says he needs the ones before so that he can show the difference.
Well, it's difficult to see why he would need those, Your Honour. I mean, his own client was, as I say, the general manager until May 2023. He must presumably be familiar with the kind of arrangements that were entered into with Al-Khalij. Indeed, he's pleaded in paragraphs 12 and 13 of the reply to defence to counterclaim, as I've shown you, what the arrangements were. And that's all relating to the period prior to him being removed as a general manager. So I do say this request is something of a sledgehammer in terms of how it tries to identify what Mr. Doherty says the alleged diversion of business is. It's overly broad for those reasons.
Yes.
In terms of the relevance and materiality, I can deal with that fairly briefly, because it's something of a similar point. The point is, as I said, on the pleaded case, there isn't a specific time period identified whereby or whereat the first defendant says there was a change in what Al-Khalij was doing. And following that point, Al-Khalij started diverting business. So the point I make is on relevance materiality. Not all of the contracts can be relevant or material to assisting the court in determining whether there was a diversion of business. And I go back to the point I made on legal principles in the context of request 1, which is that relevance and materiality is judged in terms of whether the documents are sufficiently relevant to material. The purpose of the document production regime and having requests to produce is to make this an efficient and streamlined process, and for only documents which are going to significantly influence the court's decision to be produced. And I say that documents predating an unspecified date where Al-Khalij, where on the defendant's case there was some diversion of business, are very unlikely to assist the court. So for those reasons, Your Honour, I invite you to reject this request.
Did you, I'm not sure if I misunderstood, did you suggest a date range, or I thought Mr. Doherty said something like to the effect that there was a difference between you about the date range, or?
Well, I don't, we haven't proposed a date range.
You haven't, all right.
The date range that's been proposed by the first defendant is the 1st Jan 2015 to present. We said that's too long.
Yeah,
I think just to clarify that point, the original schedule didn't say the date range. It was on the application. We said we're content to do it from 1st of January 2015 onwards. So that's where the date range was introduced. There are a few. I think Mr. Jackson was finished. There were just a couple of brief points. The first is an overarching one, which is the only basis on which Al-Khalij can use either Medica Plus or Medica Cloud Care is because of the license granted to it by Health Insights Dubai, which permits that. Otherwise, it has no legal right to roll out the software to any facility. Any contract that it has for the rollout of Medica Plus or Medica Cloud Care, for which it doesn't pay Health Insights Dubai, is a diversion of business. And that would mean that to the extent that it is withholding payment under old contracts, or whether it is deciding to pay other entities controlled by the claimants for the entry into new contracts, those are all relevant, because if Al-Khalij is getting the benefit economically from the use of medical care without paying Health Insights Dubai, on the first defendant's pleaded case, that is a profit for which the claimants, or at least the first claimant, has to account to Health Insights Dubai for. So the criticism
on the first defendant's case, is there an earliest date by which that diversion took place? I mean, do you say that it took place right from the commencement of the rollout of MCC, or was it a later time?
No, it seems as though the period in time in which there is at least the beginning of payment issues, or not all invoices being fully paid up, was from the 1st of January 2020. When it comes to the dates for the provision of contracts, the reason we maintain the earlier dates has to do with partly the nature of the contracts themselves. So, for example, what might be the case for at least some of the contracts, so for example, the contracts with the 23 hospitals, or the ones that we already have at least some reference to in the invoices, is it wouldn't necessarily be surprising if that was a contract that was originally entered into at a prior date, where there's an annual renewal cycle. So it might well be that the terms upon which it's renewed refer back to some earlier document. So if there is an earlier contract from 2015 or 2016 or 2017, which is rolling on, that contractual document is going to be relevant in one of two ways. One, because the contract continued and Al-Khalij continued to get payments under the contract, and what's changed is they've just stopped paying Health Insights Dubai. Or because there's a subsequent change in the terms which permit some form of diversion of the income. But on either analysis, the earlier contract would be relevant and material to either there being a continuance of terms or there being a change in terms based on the facts of the case.
And are those contracts confined to what you've put in your paragraphs 12 and 13 that Mr. Jackson took me to? That is the contracts before 1 January 2020.
You mean for the prior period?
Yes.
So, so I suppose for the period prior to 1st of January 2020, those are the contracts, the existence of which we are aware of. And I suppose to put it in these terms, the first defendant has knowledge of the existence of those contracts, and of course he does, he's pleaded it. His knowledge extends to the knowledge he obtained in his capacity as a director of Health Insights Dubai, not Al-Khalij. So whilst we know about the existence of the contracts, of course, we never actually have a copy of the contractual terms, which are Al-Khalij documents. So we have knowledge of, but not possession of the contracts themselves. I suppose, could one say that for the period prior to the 1st of January 2020, they should disclose those listed contracts? That's possible, but that doesn't really answer the problem of what happened afterwards, what happened after the dispute arose, where clearly in this sort of case, the first defendant is going to be undecided. It's not a particularly convincing answer for the claimants to mind what we say is a pretty circular argument. It says, they say we won't give you the documents because you can't specify what they are, but that's precisely the reason we're seeking copies of those contracts, because they're relevant and material. There's no denial that the contracts exist. We say that insofar as Al-Khalij entered into contracts with anyone concerning the rollout of MCC, they're all relevant contracts, because the only basis on which Al-Khalij is permitted to economically exploit MCC is due to its relationship with Health Insights Dubai. So they must be relevant. I don't see how there's a basis to say some of Al-Khalija's contracts might not be. If it helps, we don't want their broadband bill or contracts with their office providers or anything like that. We're talking specifically about contracts which they have entered into in respect of Medica Plus and Medica Cloud Care.
I think that's what the request says, doesn't it?
It is. So that's why we say it's sufficiently narrow to identify them. It should be pretty easy to identify from invoices Al-Khalija have issued which facilities they're providing services to. And so it is an identifiable subset of documents. They're quite clearly relevant. And so that there's no basis to narrow the request as it's put. It's already sufficiently narrow.
Yes, all right. Thank you. Well, for the reasons that Mr. Doherty has put, I'm satisfied as that the request is sufficiently relevant and material, and the category of documents is sufficiently focused. So I will require request 2 to be answered relating to the date range that Mr. Doherty has specified, which was 1 January 2015 on. What's next, Mr. Doherty?
Next, we have request 6. So this is contracts entered into by Health Insights Egypt, Health Insights Saudi, or any subsidiaries, whether in Egypt, the Kingdom of Saudi Arabia, or elsewhere, relating to the sale, implementation, or maintenance of Medica Plus and MCC. So we've already gone to the documents, which show, well, the underlying documents, for example, the court documents in Saudi Arabia, where it's being suggested that the party entitled to payment was Health Insights Egypt, not Health Insights Dubai, and also the subsequent invoices in 2023, which showed that sums were being paid by Al-Khalij to Health Insights Egypt in respect of maintenance implementation contracts for MCC. So the documentary record that is available shows both that third parties continue to use MCC, but that the Health Insights entities which are benefiting from that appear to be Health Insights Egypt, and on the first defendant's pleaded case, Health Insights Saudi Arabia. Now, obviously, Mr. Shehata doesn't know the full extent or the precise names of the entities where the payments are actually being received. There is the assertion put that it's Health Insights Egypt, Health Insights Saudi, and other Health Insights branded companies, which they have set up. So that's the request 7, part 1. To the extent that any of those entities are entering into contracts in relation to the sale, implementation, and maintenance of Medica Plus or Medica Cloud Care, that is relevant because it speaks to the diversion away from Health Insights Dubai of revenues that historically we have evidence it was receiving. And having regard to the fact that, of course, Mr. Shehata has not had disclosed to him to date by the claimants where they're, on our case, siphoning these monies off to, it is notable, again, that the claimants haven't denied the existence of these contracts. They don't say, well, there are no such contracts, either in relation to Health Insights Egypt or Health Insights Saudi. Again, if no contracts existed which matched this description, it would have been very easy for them to put in a statement and say that. They haven't done so. They haven't said Health Insights Saudi doesn't have any documents in our possession, custody, or control responsive to this. One point which they do take is to say that as a shareholder of Health Insights Egypt, Mr. Shehata might have been able to get hold of these documents. Again, you have my submissions on that. As a shareholder, he doesn't have a right to request the company's contracts. I don't understand that in my learned friend's skeleton that a point is even taken on relevance and materiality, and that's quite sensible because to the extent these documents exist, to the extent that HI Egypt or Saudi or the other entities have entered into these contracts, they're quite obviously relevant and material to the diversion of income away from Health Insights to Dubai. The objections taken on breadth are slightly an oddity insofar as I think what Ms. Roshan says in her third witness statement is to the effect that, well, this could potentially capture a broad category of documents. But that in itself is probably quite alarming, because if the concern is that there are so many contracts that it would take a long time to search, it rather underscores the basis on which the first defendant puts his case. Quite simply, there shouldn't be any contracts at all. So the existence of potentially quite a large volume of responsive material is of concern. The date range sought in respect of this request is only from June 2022 onwards. So that would deal with the fact that in this period, we're not only talking about the withholding of payments by Al-Khalij, for example. It's from this point in time that we say that there's a dispute between the parties, and so they've decided to cease payments to Health Insights Dubai, and those payments will then go somewhere else. So if Health Insights Egypt or Saudi or other entities are contracting after that period of time, we say those contracts should plainly be disclosed. A point I think is taken to say, well, we haven't identified the names of any subsidiaries. Again, the same point about subsidiaries or parents would be made about the existence of other companies. Just because we don't know they exist doesn't mean that they're not receiving funds. The claimants will, of course, know which companies are receiving money and in what way. And if they are, they should simply disclose that. If there are no subsidiaries, they can say that in a document production statement and verify it by a statement of truth. And so the appropriate course would be to make the order in those terms and let the explanation be provided in the normal way in the document production statement, which the claimants can be cross-examined on if required. And that, I suppose, feeds into then request 7.2, which is if we have the existence of entities which are trading in competition to Health Insights Dubai, it is reasonable to expect that in so doing, i.e. in trading in competition, they will have entered into contracts which relate to the use of M+ or MCC. And if those contracts exist with those entities, then those should also be disclosed. So request 7 Roman numeral 2 effectively follows on from the two we've already looked at. So we've got the Al-Khalij contracts, we've got the other side of the equation, which is the Health Insights entities which are receiving the income for the rollout. And those are the points. We say that it's, it should be pretty straightforward for the claimants to identify which of their companies are receiving income in this way and who's contracting. So it is sufficiently narrow, the documents can be identified. So we don't suggest any changes to the form of order sought.
Thank you, Mr. Jackson.
Your Honour, in relation to request 6, our objections are in some ways similar to some of the requests we've already considered. There are essentially 3 objections. 1 is on the breadth and proportionality, 2 is on sufficient relevance and materiality, and 3 is on whether the documents, insofar as the request relates to HI Egypt, are already in D1's control. The point I really want to focus on in relation to request 6, though, is the language of or any of their subsidiaries. Now, ultimately, document production has to be framed by reference to what the pleaded case is. What D1 has not pleaded is any case that there was a diversion of business by the claimants to any subsidiaries of Health Insights Egypt or Health Insights Saudi. So it doesn't identify in its pleaded case that there were such subsidiaries or that there has been diversion of business to such subsidiaries. And the reason why that's relevant in my submission is because it would have been in my submission, open to D1, or it would have been something he was able to do, based on, first of all, his knowledge as the director of HI Dubai, in fact, its general manager, up until May 2023. And secondly, his position as a director, in my submission, the CEO of HI Egypt, up until 2022, and as a continuing shareholder in both companies. In all of those capacities, he's very likely to have had information as to whether these companies had subsidiaries. And even in the period post the dispute between the parties arising, information of this sort is usually obtainable from public authorities. And we've seen in relation to the Dubai entity, for example, its commercial license in the bundle. So there's no good reason in my submission for any subsidiaries not to have been identified in the pleading. And for that reason, I say that that part of the request in particular is too broad. And if Your Honour were minded to grant this in some form, in my submission, those words should be deleted.
Yes.
So, Your Honour, if I may just very briefly
Yes.
on the pleaded aspect of the case. Again, it's to clarify, this request is from June 2022, which is when Mr. Shehata ceased to be Director of Health Insights Egypt. Of course, the point made about subsidiaries wouldn't apply to Health Insights Saudi because Mr. Shehata isn't a part of Health Insights Saudi anyway. But the
I
broader
think
point
one of the points Mr. Jackson was making is that that information is publicly available.
Well, I'm not sure on the basis upon which that's said. I don't know what the provision of the company's law is in Saudi or the various other of these jurisdictions. But the broader point on the pleaded case is that what we say is that it has been diverted to these two named entities, which we do know about, or to other entities which are controlled by the claimants.
Is that what you plead?
Yes. Bear with me, I can find you there are a few references to that in the pleadings. So, for example, diversion of business at page 33, paragraph 68 says hospitals which have entered into contracts with Al-Khalij and or other entities owned or controlled by the claimants continue to use the MCC software.
I see.
So it's always been, we're aware of Health Insights Egypt and Health Insights Saudi. There are other entities which are suspected of having been set up, and references made in the application, for example, to Health Insights Rwanda. But the broader point is whether, if there is a company which has been set up in competition or is trading in competition to Health Insights Dubai by offering hospital software or hospital implementation systems or whatever it happens to be, it doesn't really matter whether it's a completely separate company or whether it's a company within the same chain. So if it's a subsidiary of Health Insights Egypt, rather than Health Insights Egypt itself, it would still be caught by, for example, request 7, which deals with other entities. So the idea whether, well, the suggestion that it's too far to say that subsidiary shouldn't be caught is a bit of a red herring, because the key point is, if there is a business which is contracting in a way that they shouldn't be because they are contracting for the rollout of MCC, then those contracts should be disclosed, whichever entity it is controlled by the claimant. So if it's a subsidiary, so be it. If it's a completely separate company, so be it.
Yes. All right, thank you. I'm satisfied that the request is for documents relevant or sufficiently relevant and material. As to breadth, I do not consider the addition of the words or any of their subsidiaries to be unduly broad. The claimants are able to identify companies that are subsidiaries of those two companies, and whether they've entered into such contracts. As to the documents being in the first defendant's custody, possession or control, the request is only for documents from June 22 onwards, and the first defendant did not have custody, possession or control from that time. So those requests should be answered. What's next, Mr. Doherty?
The next, I suppose, is to confirm request 7, Roman numeral 2, which is
yes,
the other.
I was referring to both of them, and
okay.
I said that one should be answered as well.
Thank you. The next cluster is in relation to effectively flow of money. So requests 3 and request 10 relate to payments arising from this activity. So request 3 is documents showing payments requested and or received by our college with respect to the sale or licensing or support services provided in relation to Medica Plus or Medica Cloud Care from the hospitals or healthcare providers or government ministries or entities. So inevitably, this is going to be tied to those entities which is contracting with. The basis for asserting relevance and materiality, I hope, should be pretty clear. If there are contracts which they're getting payments for, and if those payments aren't in proportion being remitted to Health Insights to buy, that is an amount of money which the claimants or the first claimant has obtained as a benefit or profit to which they should account to the company in respect of. So it's really just the final part of the puzzle in respect of this issue of diversion of income. The pleaded case, of course, is that Al-Khalij is taking the benefit of generating income from MCC, which are being rolled out to healthcare facilities, and that those payments were then stopped on the first claimant's instructions, which we already have documentary evidence for. I understand the claimant's position to be that they do now take objections based on relevance and materiality. I note that that objection was not set out in the claimant's original objections to the request to produce. And I think that the point that is now made is a somewhat half-hearted attempt to say that, well, not all of those payments could be relevant. But it's respectfully quite hard to see how that can be the case. If one looks at the terms in which this is drafted, it's documents showing payments requested and received with respect to the sale or licensing of Medica Plus or Medica Cloud Care. So if there are payments received which are unconnected to the rollout of those products, that's not caught by the scope of the request. We're only requesting payments which have been received for the economic utilization of this software, which, as I've already said, can only have been by virtue of Health Insights Dubai permitting that activity to be carried out by licensing Al-Khalij to carry out the business. So any payments received which match that description are relevant and material to this case. The second point is that the requests, we say, are clearly sufficiently specific to identify the categories of documents. So documents showing payments requested and or received, well, requested would be an invoice sent to the hospitals, for example. Received would be some form of remittance or a bank statement showing the incoming payment, or some other evidence of actual receipt, or indeed just Al-Khalij's own internal records of payments. It's not difficult for a business to understand where its flow of money is coming from and to know where to look for that. I think it's the thing that most businesses are most concerned about. And the dates proposed, we say, are reasonable and proportionate, which is from 2020 onwards. And that is the period from which, in effect, payments start to slow and partial payments start to be made. So either there's a question of the retention of money by Alcalige or the money going somewhere else. But in either event, that is a proportionate date range.
Thank you. Mr. Jackson?
Yes, Your Honour. Just to clear up one point, in relation to relevance and materiality, that is an objection that we raised in our evidence in response to the document production application. I don't think I need to take you to it, but it's page 191 of the bundle, paragraph 26, Ms. Roshan's witness statement. Our main objection to this concerns the breadth and disproportionality of the request. And there are a few points I want to make in relation to that. The first point is in relation to the use of the word documents. Now, I made submissions to Your Honour earlier in the context of the requests concerning ownership and management. And Your Honour's ruling, as I understood it, was in relation to that issue. The subject matter was sufficiently defined for the fact to mean that the use of the word documents in relating to was not problematic. Now, I do say that different considerations arise in respect of request 3, because documents showing payments requested and or received could be very, very broad indeed. So, for example, and this is our particular concern, emails or other correspondence which refer to payments requested or received by Alcalige would, on the face of this wording, be captured. And that is likely to be very broad indeed. Now, what Mr. Doherty seemed to suggest in his oral submissions was that what he was really targeting was invoices or receipts or documents of that sort of nature. But that is not what, on the face of it, the request provides for. And we say that an open-ended documents type formulation is too broad.
Well, taking on the first part, so if I can understand what you're saying, if the wording were, instead of documents showing payments requested, if it's a documents requesting payment, does that overcome your breadth issue so far as requests are concerned?
Well, it doesn't, Your Honour, in the sense that there may well be extensive correspondence, one doesn't know, in which payment requests are mentioned, which would be captured by that. Now, if what's being sought is invoices or receipts, then the appropriate way, if Your Honour were minded to make any document production order, would be to amend the request so that it just reads invoices and or receipts relating to or with respect to the sale and or licensing and or support services between Alcalige and the hospitals. Now, I do say that no document production order should be made, but insofar as Your Honour were minded to grant one, that's the way in my submission it should be curtailed. It's difficult to see what the first defendant would need beyond that.
Well, I suppose might be invoices, receipts, bank statements, and journal entries.
Well, in relation to bank statements, Your Honour, I mean, if Mr. Doherty's case is that any diversion of business or any distribution of MCC without authorization by HI Dubai would be a diversion of business by Alcalige, the key documents that that would be necessary for his purposes would be invoices and receipts. In relation
on that, I don't know how the business operates. Some businesses don't issue receipts. I'm thinking very personally, and it may be that I'm lax, but I issue invoices. I don't issue receipts. The way you tell whether I've received a payment is either a remittance from the sender or the bank statement. So perhaps remittances are there, but I say not all receipts aren't always issued, I don't think, in business.
Yes, that's fair, Your Honour. I mean, remittance might be a better way to cover it.
Well, invoices, remittances, receipts, and bank statements. I don't think one can avoid the bank statements because, say, at times, again, my experience is that at times purchasers, customers simply pay and the money is deposited to the bank without a remittance being sent, even in my experience where I've requested it.
Well, I can see that, Your Honour. What I would say is that this has to be borne in the context of all the document production orders that Your Honour has granted. What Your Honour has already ordered in relation to Albulaihid is that contracts with other entities will be disclosed. So my submission, that I mean, there is already that source of documents to the extent that they exist, that Mr. Doherty would be entitled to marry up with invoices, receipts, etc. under this. In my submission, including bank statements, wouldn't be proportionate, particularly given the date range that's proposed of over 5 years.
So the bank range is from 1 January 2020, isn't it?
Yes. Yes. And it should be more borne in mind as well that in terms of the counterparties that are mentioned within this, you have my submissions on why we say it's not appropriate for them not to have been identified. But even if Your Honour's not with me on that, that has to be borne in mind in terms of the scope of the documentation that's already being provided, to the extent it exists. So if one is to provide invoices, receipts, and or remittances for contracts or any dealings between, or rather contracts between Albulaihid and these unidentified entities, that is potentially very broad in and of itself, particularly given the date range. So, as I said, if Your Honour is minded to grant this request, and for the reasons I've submitted, I say it should be rejected, I would invite Your Honour to curtail it in the way that I've suggested, so that there are specific categories, namely invoices, receipts, and or remittances.
Yes, all right.
Very briefly, if I may, Your Honour.
Yes.
But it's really just to echo the point that Your Honour made, which is I don't know what the arrangements internally with the company are, or the way in which documents are stored, or how invoices are sent out, and so on. What needs to be provided is a complete record of payments which are actually received, because those are clearly relevant to the claim for an account. As you say, might well be that those are invoices and receipts. To the extent those are missing, it's the bank statements which are going to show it. One always starts with the premise that documents should be provided in complete form to avoid us coming back before court to have arguments in due course. But even if there was any concern about that, one could limit the scope of what's being disclosed in the bank statements to the payments that are actually received from the various government entities or healthcare facilities. So if there's a payment going out for internet provision or something like that, you can simply redact the irrelevant stuff out. We would say that it would be easier to simply provide a complete record of the statements, but insofar as that is a concern, that would be the appropriate way in my submission to address it, which is to provide, as we have in these proceedings, got copies of redacted bank statements showing the flow of payments from Albulaihid to the second defendant.
Yes, I'm looking at I will allow the request, but confine it instead of to all documents showing payments requested and received. It should be confined to invoices, receipts, remittances, and bank statements. And as Mr. Doherty has suggested, it would be a matter for the claimants, whether they, in relation to bank statements, whether they wish to produce the whole of the bank statements, or whether they wish to redact them so that only the receipts in respect of those matters are shown. And it is for the date range 1 January 2020 onwards. So instead of all documents, Mr. Doherty, to be confined to invoices, receipts, remittances, and bank statements.
Yes, thank you. The next, Your Honour, is request 10, which is in effect, as with the contract, the other side of the equation. So if Albulaihid is generating this revenue, but there are payments which are not going to Health Insights Dubai, then the question is, well, are there other Health Insights entities controlled by the claimants where the payments are going to? So this is invoices, receipts, or any related documents from 2021 onwards showing payments by Albulaihid to Health Insights Egypt, Health Insights Saudi, or any other entity trading under the name of Health Insights.
Well, similarly, should this practically be confined to invoices, receipts, remittances, and bank statements rather than any related documents?
Yes, that would be consistent with where we've got to on breadth, and I don't think that there's any objection made here on relevance or materiality. So, assuming that we've hammered out the issues on breadth, it may well be Mr. Jackson can let me know if there's any other points I need to deal with, or I can deal with in reply. But it seems to follow from what we've discussed already.
Mr. Jackson, is breadth the issue on this request?
Yes, we did also raise.
Sorry, carry on.
We did also raise an objection based on possession, custody, and control insofar as it relates to HI Egypt, but you already have my submission on that in relation to other requests. In terms of breadth, if Your Honour is minded to document production order, in short, we agree with Your Honour that it should be curtailed in the way you've described.
All right. Well, I will required to be answered and to be limited in the way that I said, that it's to be invoices, receipts, remittances, and bank statements.
The next category or subset of documents, Your Honour, I should hope should be relatively quick. They're not picked up by the claimants in their submissions or skeletons, because I think they might have slightly misunderstood our position. So this is requests 8 and 9 and 14 and 17, each of which are requests which, in effect, they've been agreed to. So it has been agreed we will go and search and produce documents responsive to these requests. The position from our perspective is we don't think those searches or reasonable searches have been carried out, because we haven't received any documents where we have reason to believe that documents should exist. So to give you what they are, request 8 is documents in connection with the intellectual property rights and or copyright or trademarks in connection with the MCC software, the registration of the software by HI Egypt, so including correspondence and communications with the relevant authorities. Now that arises because we have a certificate in documents that are available showing some registration being made before the Egyptian Ministry of Communications and Information Technology. So this request was, well, what's the background and context to that registration occurring, which one would assume includes some form of submission or correspondence or communication with the relevant authorities. And despite the fact that it's been agreed, those documents have not been provided. All we've got is the certificate itself, which is at page 1742. And then request 9 is communications between internal to the claimants, in effect. So it's email and WhatsApp communications in connection with that registration. So what they discussed amongst themselves. And again, that was agreed to, but what we don't have is the production of any documents. So we don't know whether a search is actually being conducted or not. So given that these are agreed, in my submission, the appropriate course would be to make the document production order, and then an explanation can be given in the document production statement as to the searches carried out. And the other two that this applies to are requests 14 and 17. So that is communications between the first and second claimant from the 1st of January 2021 concerning 1, the MCC rights, 2, the decision not to pay the second defendant sums in respect of the MCC rights, 3, the decision to remove the first defendant as general manager of the second defendant, which of course ties into the unfair prejudice petition, and 4, their communications in relation to the marketing and sale of MCC by entities which they control other than the second defendant, and 5, legal proceedings brought by them on behalf of companies that they control. And then request 17 relates to documents filed on the DDA portal that resulted in the change of general manager, and the documents between the claimants and the DDA relating to that. And again, those were agreed, responsive documents, save for very limited sets of communications in respect of request 17 Roman numeral 2. Aside from that, nothing has been provided. So again, what we suggest is that the document production order should be made, the terms have been agreed, and the explanation can then be given, if there are really no documents, what search has been carried out, and why it said in the document production statement that none have been found, and that can then be verified by a statement of truth.
Yes. Mr. Jackson? Doesn't seem to be any dispute, is there?
There is, Your Honour, in relation to this.
So what is the dispute?
So the reason, I mean, Mr. Doherty mentioned that this wasn't addressed in my skeleton. He's correct. The reason it wasn't is because it hasn't formed an active part of the first defendant's application until Mr. Doherty's skeleton was served. And if I could just walk Your Honour through that briefly. So if we start with the first defendant's application for document production, so that's at page 146 of the bundle, section C, tab 2.
(146).
Yes.
Yes.
So this is the first defendant's. It's called an application. It's actually sort of a submission in support of the application. And if Your Honour goes forward to page 155.
Yes.
Paragraphs 32 to 35 deal with request 8, and paragraphs 36 to 38 deal with request 9.
Mm-hmm.
And Your Honour can see that at paragraph 34, D1 says, so far cease to disclose no documents beside those which D1 has already relied upon in these proceedings, principally a document issued by the European Ministry of Communications and Information Technology. And 35 says, unclear whether further searches are being undertaken or not, D1 reserves the right to seek a document production order in respect of request 8, insofar as no further relevant documents are disclosed. So, in fairness to Mr. Doherty, the right is being reserved to seek a document production order, but there is no contention at this stage that that's what's actively being sought. And the same point arises in respect of the other requests, which are request 14 and request 17. Now, in Ms. Roshan's third witness statement, we responded to this, and Your Honour can see that at page 187 of the bundle.
Yes.
And at paragraph 8, in the second sentence, Ms. Roshan says, the application also refers to the other request to which the claimants agreed in part or in full. However, no order appears to be sought by Mr. Shehata as to those requests. And there was no, following this, there was no reply evidence, as I mentioned earlier, that was served in response, saying, well, in actual fact, we are seeking a document production order in relation to these requests.
Well, I'm not sure that I follow. Are you prejudiced, or what's the problem with you giving a statement? You've made the inquiries, you've carried them out. If you're ordered to, if I make a document production order in relation to these paragraphs, you'll just say what the searches that you've made the appropriate searches, and these are the only documents they've disclosed. That's what you've already done. What's the looking at the substance rather than the form of it all?
Yes.
What's the problem?
Your Honour, I can see that if what's looking to be achieved is for us just to explain what searches we've carried out, we don't have an issue with that. But the point I was getting to was in terms of the criteria for making a document production order. The criteria that Mr. Doherty must be relying upon is that we have failed to carry out a reasonable search. And Your Honour, I don't know if you have the RDC rules in front of you.
Yes.
It's Rule 28.36.
Yes.
So subparagraph 1 deals with the sort of objections to requests that we've been looking at up until these specific ones we're now considering. Subparagraph 2 applies where the responding party has failed to carry out, or where a requesting party considers that the responding party has failed to carry out a reasonable search for documents which have been requested, or has otherwise failed without objection to produce such documents which are within his possession, custody, or control. Now, the way in which I object to this is I do say it wouldn't be fair to my clients for an order to be made on the basis that they have at this stage somehow failed to carry out a reasonable search. And if that's the basis on which the document production order is being sought, then
can't I look at the order in the broad, that I don't have to look at each specific request? Can't I look at it on the basis that you've made some objections and they're not justified? I'm going to make a document production order and it's going to refer to all of these. I'm not going to make a finding that your client has not carried out reasonable search. But it does seem to me that the practical approach to this matter is to make a document production order in relation to all of the requests that we've dealt with today. And to say that I make no finding that your client has not carried out a reasonable search.
Yes, Your Honour. If Your Honour is making it on that basis, that meets my concern, certainly. The reason I raised it is because the only basis upon which Mr. Doherty can make the application for that specific part of the document production order is the one I've just shown you under subparagraph 2.
All right.
But if you're not intending to make a finding on that, then
I do not make a finding that your client has failed to make a reasonable search, but I will make an order that there to be a document production order, and it will be in relation to all of the requests that we've dealt with today.
I'm grateful, Your Honour. I think that deals with certainly the claimant's position on all of requests 8 to 9, 14 and 17 then.
And it is, according to me, just after 1 o'clock in Dubai, which this might be an appropriate time to take a break before we deal with the claimant's application. Well, perhaps I should just clarify. Have we dealt with your application, Mr. Doherty?
No, there are a few more, but it's still potentially an appropriate time to take a break. So we've got requests 11, 12, 13, 15, 16, which are all shorter than what we've dealt with.
I hope so.
And I think the claimant's application, should be the points are narrower and should be shorter too. So now might be the appropriate time to break.
All right. Well, shall we confine? I'll just ask the court officer, is there a difficulty with us breaking for only half an hour?
Of course not, Your Honour.
All right. Well, I'll ask Mr. Jackson, Mr. Doherty, do you want more than half an hour?
Not for my 10 a.m. here.
You're probably, I say it's 10 o'clock where you are, is it?
Yes.
Yeah.
Well, it's neither breakfast nor lunch, so perhaps half an hour will do you. We'll resume then at, we'll give you the full half hour. That'll be 10:35 your time, 1:35 in Dubai.
Thank you.
All right.
Thank you.
Thank you. All right. I can see Mr. Jackson and Mr. Doherty. I'll just check I think everybody else, just check with the court officer. So far as you know, is everybody present who intends to be present?
Thank you, Your
Yes. All right.
Thank
Thank
you.
you. All right. Well, Mr. Doherty, please continue.
Thank you, Your Honour. The next one is request 11, which I think should be pretty straightforward based on some of the discussions that we've had this morning. So this is financial statements relating to the various companies we've been discussing this morning. So Al-Khalij, HI Saudi, HI Egypt, and other companies that include the word health insights or similar. As I understand it, no objection is made on grounds of relevance or materiality, which is perhaps unsurprising because those documents would show revenues generated by those entities, which on the first defendant's case would be revenues to the detriment of the second defendant. The objections raised are that these are, at least to some aspects of the request, to unidentified companies. We say that that's not a legitimate objection based on the points we've dealt with this morning, which is if materials end up being disclosed showing that these companies exist and that they are generating income and so on from the use of MCC, then it's those companies who ought to be producing financial statements. So it follows on from the scope of disclosure that has been ordered so far. And in any event, the request here specifies that it's companies formed by the claimants, including the words health insights or similar. So it should be easy for them to identify which are the relevant companies. And then the second point of objection, I think, is one which again has been dealt with, which is this point about possession, custody and control of Health Insights Egypt documentation, which I don't think we need to necessarily go over again. And assuming those are the only objections, this should be relatively straightforward.
All right. Thank you, Mr. Jackson.
Yes, Your Honour, you have my submissions in relation to the points that Mr. Doherty has just dealt with. I made the same ones as I did in respect to previous requests. But I acknowledge
All
Your
right.
Honour's.
Yes, well, I think it follows. Was there anything else you wanted to add, Mr. Jackson?
The only other point I wanted to add, Your Honour, was in terms of the years that are specified. Currently, as drafted, the request includes the years 2020, 2021, and in my submission, it goes back to the point I raised earlier about the first defendant not having identified when exactly the diversion of business is alleged to have happened. If its case is that this arose after the dispute between the parties in 2021, then in my submission there's no reason to include accounts for 2020. That's the only point I make in relation to that.
Yes. When did the dispute between the parties occur or start, or when should I fix it?
In relation to, my understanding is that in relation to the Egypt entity, there was a dispute that took place in 2021. I mean, as with disputes with shareholders, these things tend to rumble in one way or another. But I think the focus of the dispute really came to the fore in 2021. As regards the Dubai entity, Your Honour is obviously aware from the history of these proceedings that the real focal point of dispute erupting on that was the resolutions that were passed by the directors of the Dubai entity on the 16th of May, or the 16th of May 2023. So that is my submission on when the dispute arose.
Mr. Doherty, just on the dates.
Certainly. The two reasons why it's from 2020, one is that's the period from which one starts to find partial payments being made. So Health Insights Dubai not receiving full amounts due from Al-Khalij. And so 2020, we say, is properly included on that basis. But there's also, in respect of the other companies, a proper and reasonable grounds in which to maintain those dates too, because of course, if what one sees when you compare, for example, Health Insights Egypt's 2023 accounts and their 2020 accounts is a sudden growth of income that's being recorded that had not historically been recorded to the benefit of Health Insights Egypt, that somewhat shows that the revenues are being moved from one entity to another.
Yes.
Rather than having, yes.
All right. Well, I'm satisfied for reasons I've given earlier that the request should be answered, and I'm satisfied that it should be for the years 2020 through to 2024. Yes, what's next?
The next is documentation concerning an expert report. I think there's been, well, it's not quite talking at cross purposes, but there's been an iteration from the claimants that we don't understand.
Which number is it?
Apologies. This is request 12, which is a report commissioned by the claimants by Dubai-based intellectual property expert in connection with the MCC rights, together with supporting documentation. So this is a report which was prepared by Dr. Abdulrahman Al-Muani, which was prepared for the claimants in their capacities as shareholders of Health Insights Dubai. And that was said to concern the ownership of the MCC rights, which is in issue in these proceedings. And the content of that report sought to establish that the MCC rights belonged to HI Egypt, not HI Dubai, which on the first defendant's case runs contrary to the position adopted by the claimants in these proceedings, because in these proceedings, their assertion is that MCC was owned by the second defendant and it was in effect transferred to Health Insights Malaysia at an undervalue. Now, if the case that's being put by the claimants in this court is different to reports they have obtained, but also the case that they have been positively advancing in other jurisdictions about the ownership of MCC by Health Insights Egypt, we say that's relevant material because it concerns which of these entities owns the MCC rights and whether there is a proper basis for the claimant's claim that the owner and the author was Health Insights Dubai. Now, the report or extracts of the report have been obtained by the first defendant, and I think that's been obtained in the context of court proceedings elsewhere. But what it refers to is, for example, documentation that the expert relied upon in forming the view. And so the request is for the full report and the supporting materials. Now, the objections that I understand are presently advanced are that there isn't enough detail to identify what this report is about. We say that's a bit of a sleight of hand. It should have been obvious to the claimants what this request was talking about because they're the ones who obtained the report. But in any event, if it helps them to identify the report, I'm happy to include the words, the report prepared by Dr. Abdul Rahman in the description provided. The second objection taken is that some parts of this request may be privileged. I don't think there's a positive assertion that it is privileged. And one suspects that one would have to establish a basis for saying that it's privileged if, for example, it's a report prepared by or for court proceedings where privilege isn't necessarily a recognized concept. But be that as it may, if there is a proper basis on which to assert privilege, then that can be dealt with in document production in the normal way, which is you say, we're withholding this from inspection on grounds of privilege. But that doesn't entitle one to withhold the remainder.
All right. Mr. Jackson?
Your Honour, in relation to this request, I do say that the way in which this request has been formulated is unsatisfactory. If Your Honour looks at the original formulation that was sought, that's at page 113 of the bundle. That's section B, tab 3, page 113.
Yeah.
And Your Honour sees under row 12, that's the description: a report commissioned and or provided to the claimants by Dubai intellectual property expert in connection with the MCC rights, etc., etc. But there wasn't any proper identification of who the report was authored by, the date of it. The first indication of the party who's said to have authored the report was in my learned friend's skeleton. That's at paragraph 103. Now, in relation to that name, Dr. Abdel Rahman Al-Munaini, it's unclear who he is said to be. We haven't had an opportunity, obviously, to address this in evidence because his name was only given in my learned friend's skeleton. I have taken instructions in the time since the first defendant's skeleton was filed, and my instructions are that the claimants aren't aware of a report by Dr. Al-Munaini. Now, I appreciate that my learned friend says there are extracts which show some of the contents of the report. Those haven't been disclosed to us to date, so I'm not in a position to comment on what they are. But I do oppose the request on the basis that it hasn't been properly identified, even at this stage.
Well, if it's identified by name, by naming the expert, true, it doesn't have a date, but unless there is a myriad of such reports, I have difficulty understanding the submission that it hasn't been identified. I mean, it's identified as an expert report. The name of the person is identified and the subject matter is identified. That seems fairly specific. What difficulty is it? I say there's no date, but other than that, what's the difficulty? How could the claimants not know what it is they're being asked to produce? If they say there is no such document, well, so be it.
Well, I think this is scientifically provide the date as well. It's from the 18th of January 2023.
But Your Honour, I don't have instructions on that. The date's only been given now. So I'm not in a position to make detailed submissions as to whether they could find the report. All I have been given in my learned friend's skeleton is the name of the author, and I've taken instructions, and my instructions are they're not aware of any such report. So the additional point I would make is, on the basis of the information that I'm able to respond to, my submission is that any document production order that the court makes is likely to be futile.
Just very briefly, if I may, two things. One, I can give it to you in instruction. The opening portion of the report says the technical consulting expert report was prepared based on the request of, and then it lists the first and second claimants. We're only talking about a report prepared in the context of this dispute, some 2 years ago. They surely remember these reports that they commission about this very important subject matter. If they don't, or if they can't find it, then they can explain it in a document production statement. But there's sufficient basis to say that the document does exist and that therefore the supporting materials provided exist. Anything else can be explained in the DPS.
Yes.
Your Honour, I do push back on that on the basis that if the doxy is quoting from an extract that his side have not disclosed to us and have not put in evidence. So when he says there is sufficient evidential basis to conclude that the report exists, he's making that on the basis of a document that neither you, Your Honour, nor I have seen. So I do resist it on that basis.
Well, I will make the order. It will be amended to include the name of the expert and the date that Mr. Doherty has referred to. It will not be difficult for the claimants to search for and determine whether or not they have such a report or reports and supporting documents. If they are not able to find such a document, then they will state in the document in the statement the searches they've made and that they have not been able to find such a document. But I will make the order. Mr. Doherty?
Request 13 is registrations of the intellectual property rights and or copyright or trademarks in connection with the MCC software anywhere in the world by entities owned or controlled by the claimants. So this feeds on from the documents which are known to exist, which are the registration certificate before the Egyptian Ministry of Communications. The basis upon which this request is objected to is not, for example, relevance and materiality. It should be pretty clear why it's relevant. What is said is that, Ms. Roshan says that the documents are not believed to exist. That might be fine so far as it relates to Ms. Roshan. What we don't have is any statement signed and verified by either of the claimants, who would, of course, have first-hand knowledge of whether or not these registrations or documents exist. And it may well be that this is an easy one for them to address, which is they can say in the document production statement, this doesn't exist, and so we haven't produced anything. But really, given the nature of the request, given that we know efforts have been made to register intellectual property rights in other jurisdictions, is the appropriate course would be to make the order, and that can be verified by a statement of truth.
Sir Jackson?
Your Honour, in relation to this, I do resist it on the basis that no further documents are likely to exist. Mr. Doherty has referred you to Ms. Roshan's evidence. If you could look at that briefly, it's paragraph 71 of her third statement, page 198 of the bundle, bundle C, tab 3. And what she says there is that I understand from the claimants that no documents exist save for the registration in Egypt, which Mr. Shehata already has, and that the claimants have not registered the MCC software anywhere else in the world. Now, Mr. Doherty in his oral submissions referred to other jurisdictions in which it said that the claimants might have registered MCC. I'm not clear on what those are. In relation to Egypt, there is the registration document that's already been produced in these proceedings. And the first defendant's position in relation to this really appears to be that the claimants haven't disclosed all documents that they control in connection with the registration of MCC in Egypt. But there's no basis for saying that further actual registration documents exist. There's a distinction to be drawn in my submission between correspondence related to registration and an actual registration certificate. As we understand it, what this request is targeting is the latter. And in relation to that, our evidence is that no further registrations do exist. So for those reasons, I invite Your Honour to reject this request.
The wording, Sir Doherty, is slightly odd. It refers to registrations of the intellectual property rights. It doesn't say documents relating to evidencing, constituting. Registration, I suppose, is not of itself a document, but a process or a what is it intended to capture?
I suppose perhaps that could be clarified further. It would be a certificate, effectively, of its registration.
I see.
So a document recording the registration of intellectual property, I suppose, might be a more direct framing, but he was.
So it's intended to be certificates of registration or
yes,
the like.
Yes, in effect, the equivalent category of document to what we have from the Egyptian ministry.
All right, and what do you say that Ms. Roshan says that she has been, well, I don't know, she says I understand from the claimants that no documents exist.
Yeah, really our point is on what basis? I mean, on what, is there a search? Is it because of oral instructions that they've never done it? That's not entirely clear, and it's also not first-hand, is our objection. So it may well be that that's true, but if it is true, then it ought to be verified by a statement of truth by the claimants themselves.
Yes. All right, well, I accept that. I will require it, as Docker said, if it be the case that the claimants themselves have conducted or caused to be conducted a search and have state that there are no further documents, then they can say so in their statement of truth. What's next?
Next is request 15, which is the second claimant's employment contract with Al-Khalij. It isn't entirely clear on what basis the objection is maintained. I think at one point in time it was suggested that the documents weren't in possession, custody, or control, which obviously can't make sense because it's his own employment contract. I think that the basis on which the objection is maintained is breadth and proportionality, which I think seeks to take issue with reference to any related correspondence, side letters, annexures, and so on, and relevance and materiality, the basis that they simply say the precise nature of his employment isn't relevant to the dispute. And we obviously don't agree on either point. On relevance and materiality, given that the assertion is that the second claimant acted in his capacity as a director of the second defendant, in a way where he was operating under a conflict, given the nature of his role with Al-Khalij, the precise nature of his engagement by Al-Khalij is going to be relevant to that. So, for example, his seniority, how much he's being paid, the position he occupied, and so on, will feed into questions of why he acted the way he acted, his subjective intentions, and so on. So it's relevant. Insofar as it goes to breadth, if it's really what the first defendant is trying to get across is that what we're looking for is documents that explain the whole of the contract. So not all employment contracts are the same. Some might be a freestanding document. Some can form a letter of engagement with standard terms affixed to it. And really it's to find what the active contractual terms are. Insofar as there are non-contractual policies and procedures, that's not really what we're at here. We want the document that says what his role is, what his remuneration is, what's a contractually binding employment term on him.
Yes, all right. Mr. Jackson.
Your Honour, I'm going to focus on the breadth and proportionality point. In relation to that, my learned friend's submission is that they're looking for the contractual terms, what governs his engagement. That isn't in my submission what this request currently provides for, because one has the reference to employment contract with Al-Khalij, but in the parentheses, there's any related correspondence. So that's any correspondence. Letters, one can see that that is contractual. Annexes as well, I don't really have an objection to that. It's likely to be contractual. But then policies and procedures, those can only, one would think, be policies and procedures of Al-Khalij rather than policies and procedures of an employee. So I do object to that wording as well.
Well, I understood. I assumed what it meant. It's related policies or procedures. So I would understand that to mean policies and procedures which relate to his employment contract. Say, for example, where the employment contract requires him to comply with certain policies and procedures.
Yes, I mean, I think in fairness, it can be read both ways, Your Honour. It may be that yours is the more perceptive interpretation compared to mine. I mean, my concern with it.
Well, it's a narrower one, and that is subject to Mr. Doherty telling me otherwise. In making the order, that's what I would intend it to mean.
Yes.
And would that's what your clients would be required to do and no more.
Yes. Well, if Your Honour was minded to make an order in respect of this request, my submission as to what it should be would be the second employment contract with Al-Khalij, including side letters, annexes, and policies and procedures insofar as referred to in the employment contract. And in respect to the policies and procedures, it seems unlikely that those are going to have real relevance to the specific duties which are owed by the second claimant. In my submission, it's likely to be formulaic policies which relate generally to how Al-Khalij employees are expected to behave as regards Al-Khalij, but it's unlikely to go really to what specific duties he owes. So I'd invite Your Honour to leave that out, but insofar as policies and procedures is included, my submission is that it should be insofar as referred to in the employment contract.
All right, Mr. Doherty, why, if you've got side letters, why do you need any related correspondence?
It's yes, well, quite right. Really, the operative words are the words outside of the bracket, so it's the employment contract. And then insofar as any of the subcategories of documents listed inside the brackets are contractual, they should be disclosed. So it may well be, I suppose, in principle, it's not impossible that someone could say, pursuant to our discussions, here are the employment terms, and send that by email, and here's our standard contract. So that would be fact sensitive, but really it's to capture the contractual documents. If they're contained in an email, fine. If they're not, fine. If it's a formal side letter, fine. If there's no side letter and there's no correspondence of any kind, and it's just a standalone contract, that's okay. But it really, from our perspective, what we're looking at are contractual documents. We're not looking at associated non-contractual correspondence.
Your Honour, just while we're discussing the formulation
Yes.
of the request, I do have a point on the date range as well.
Which what's the date? Yeah.
Well, currently there is no date range proposed by the first, and that is one of the bases on which we've objected to the breadth. The second claimant has been an employee of Al-Khalij going back to at least the 1990s. It's my understanding. And plainly not all of that can be relevant, and a search shouldn't be required to as far back as that. So I think it's for Mr. Doherty to identify what is the date range that he is proposing, which is reasonable and proportionate.
The Doherty?
I think one could sensibly draw, I mean, it depends. I don't know when the last revision to his contract was.
Well, if it said something to the effect of governing his employment since, if you're concerned that there might be a document which has continued on for years, I think that would be captured by referring to his employment contract governing with Al-Khalij, governing his employment with Al-Khalij since whatever might be the relevant date.
Since 1st of January 2020, and if it so happens that the contract that governed his relationship at that point was 2018, then
that would be cool.
Yeah, 1st January 2020 would be fine.
All right, then as to the might be including any contractual correspondence, side letters, and annexures. What's the policies or procedures you're after?
It would only be anything that's expressly referred to in the terms of the contract. So it's hard to presuppose what those might include, but it's not impossible that companies set out in a handbook duties which become contractual, which can be, it's relevant to this case, a duty of loyalty or something to that effect.
All right, well, I'll require it to be answered. It will be, as I've indicated, the employment contract governing the second claimant's employment with Al-Khalij since 1 January or from 1 January 2020, including any contractual correspondence, side letters, annexures, and policies or procedures referred to in any contractual document. All right, what's next?
this is the final point from the first defendant's request, which is request 16, which is documents held by the claimant in connection with their trips to Malaysia in 2012 and 2018, including email and other communications with Malaysian businesses, law firms, consultants, or healthcare providers, and calendar information with respect to any meetings that they attended. This is in relation to the knowledge that the claimants have of the basis upon which the third defendant operated as a company, and there's a dispute between the parties as to the state of their knowledge. There's no, as I understand it, dispute as to relevance and materiality. It's that the request is unduly broad and disproportionate.
On that point about knowledge, so it's the claimants make assertions about the first defendant makes, no, I have forgotten. Tell me what the point is.
So the claimants say that when their dispute with the first defendant arose, they were unaware of the existence of Health Insights Malaysia and the basis upon which it operated. And the first defendant's response to that is to say, in effect, what do you mean you came with me on trips to Malaysia in 2018 and 2012? Back in the early days when the company was being set up. So you do know, you've known about it. I haven't failed to disclose this to you. And so really this is to get disclosure of documents that are maintained in relation to those trips and the meetings that took place on those trips, because that informs the state of knowledge about what the third defendant was set up for. And this is not a request for documents going all the way back to 2012. It's specifically documents from 2012 and from 2018. So it's not in the intervening periods or in the period after. It's just the records that they have of those specific trips, of the meetings that they attended on it, and of their communications arising from it, which, because they're limited in time, should be identifiable and should be relatively straightforward to produce a search to find.
All right. Mr. Jackson?
Your Honour, in relation to this, our objection is, as Mr. Doherty said, that it's unduly broad and disproportionate. Now, our case on the incorporation of HI Malaysia isn't quite as Mr. Doherty said. We don't dispute that we're aware of HI Malaysia being established at some point. What we didn't know on our case is that it was owned, solely owned by the first defendant. Our case is that we understood it was always going to be a subsidiary of HI Dubai, the second defendant. In relation to the formulation of the request, just to run through the relevant aspects of it, one starts with documents. For the reasons I submitted earlier, I say that is very broad indeed, because it's documents of any type. The heart of the request is then in connection with their trips to Malaysia in 2012 and 2018. And the words which follow that, including emails and other communications, etc., those are inclusive but non-exhaustive words. So in terms of the subject matter of what this request is aiming at, it would include anything in relation to the claimant's trips to Malaysia. So that's the reason I say it's too broad. In relation, in addition, in relation to the parties who are mentioned in the inclusive but non-exhaustive bit of the request, so Malaysian businesses, law firms, consultants, etc., none of those parties are identified by name. And that's particularly relevant in the context of this request, because on anyone's case, during 2012 and 2018, the first defendant, Mr. Shehata, was the general manager of the second defendant, HI Dubai, and he was the one running the day-to-day operations of HI Dubai. And given that he ended up being the sole shareholder and the managing director of HI Malaysia, he could be expected reasonably to identify who those third parties are, that he understands the claimant to have met. As Mr. Doherty said, if the first defendant's case as well, you came with me, you knew all about this. One would identify who they were meeting by name, and that hasn't been done. So for those reasons, we oppose this request.
So Doherty?
Yes, really, it's about the reality of what is being requested. So the claimants don't say in response to this, well, goodness me, I went to Malaysia 5 times a year on all sorts of business. So far as we're aware, they didn't have any other business dealings in Malaysia. So it's not like this is a request where if one goes back to look at their emails from 2012 and searches for Malaysia, that there's going to be a whole raft of irrelevant material. Presumably anything that has to do with this trip, which has been organised and is retained in their inboxes, will be triggered by that search and can be narrowed down and produced insofar as its relevance to this dispute. So there's a bit of the real world that needs to be injected into this, which is we're talking about a narrow period of time. It's a single trip during the course of 2012 and a single trip during the course of 2018. The volume of documents arising from those is going to be very limited. It's going to be easily identifiable. If they don't exist, if they've been deleted in intervening years, then the document production statement, of course, can say that no documents have been found. But it's not like we're talking about the claimants having to siphon through thousands of emails to find it.
All right, thank you. I will not require this request to be answered, largely for the reasons given by Mr. Jackson. I note that the dispute between the parties is not whether the claimants knew of the existence of HI Malaysia. It is whether they knew that the sole shareholder was the first defendant. The request is not focused upon that issue. I won't require that question to be answered. Does that complete your requests, Mr. Doherty?
Yes, it does.
And there will be, of course, a requirement for a document production statement with a statement of truth. All right, so does that take us to Mr. Jackson's application?
Yes, it does, Your Honour. And I think we can deal with this, well, I hope we can deal with this more speedily.
So do I.
I'm sure, Your Honour. There are a number of requests, but what we've tried to do in our application is group them together for convenience. The order in which I'm proposing to deal with them, or I'm inviting the court to deal with them, is first to deal with request 3, then 4 to 7, then 10 to 11, and then 12 to 15. So if I can start with request 3, I set out what we're seeking at paragraph, I set up my submissions on this at paragraphs 71 to 77 of my skeleton. And if Your Honour would look at paragraphs, first of all, paragraph 71.
Yes.
That lists categories of documents which the first defendant has offered to produce in relation to request 3. And what request 3 concerns is essentially documents relating to the creation, registration and ownership of MCC and the rights to MCC. So the first defendant has offered to produce the documents at paragraph 71. And what we seek in addition is the documents that are listed at paragraphs 72 sub 1 and sub 2. So where I refer to emails, and I'll come on to those in a moment. The issue of who created and who owns MCC is a critical issue in my submission in the proceedings. And there's quite a sharp dispute between the parties as to who created and who owns MCC. So the claimant's case, as Your Honour will no doubt remember from the history of these proceedings, is that MCC is owned by the second defendant, and that what the first defendant has done in our case is purported to cause the second defendant to sell MCC to the third defendant by way
Mr.
of
Jackson, the claimants have not said, as I understand it, how the second defendant is or became the owner of MCC or the MCC rights. Is that correct?
Not quite, Your Honour. So that is a point that's advanced in the first defendant's pleadings. We don't accept.
Yes.
But if I can start with the factual position.
Yeah.
The factual position on this is that it's common ground that the first defendant, Mr. Shehata, up until at least May 2023, was the general manager of the second defendant, and in that capacity was responsible for its day-to-day operations. And one can see that from my learned friend's pleading. So if Your Honour would go to Section A, tab 4, and it's at page 29 of the bundle, paragraph 51.
Yes.
So it says it's all material time since the claimants acquired shares in the second defendant. So, and that's in July 2007. The first defendant has been responsible for the day-to-day operations and management of the company. The reason why that's relevant to the issue of ownership is because the first defendant was responsible for the day-to-day operations of the second defendant. The claimants were, in our case, reliant upon what they were being told by him. Now, in relation to our pleading on ownership, what we said, and I'll just take Your Honour through it quickly, is that if Your Honour would go to page 12 of the bundle, this is in Section A, tab 3, and it's paragraph 13. And what's said there is that at all material times prior to the 19th of December 2021, the second defendant owned the intellectual property rights in certain software known as Medica Cloud Care, and that's based on our understanding at the time, based on what we understood from the first defendant. And the relevance of the 19th of December 2021 date is it reflects the purported date of the assignment agreement, which Your Honour I know has seen during the course of these proceedings before.
So, Mr. Jackson, do I take it that either the claimants at this time have not condescended to, or at least their pleadings don't condescend to, how they became owners of the software?
Yes. How the second defendant became the owner of the software.
How the second defendant did.
That's right, Your Honour.
So I don't know, for example, whether the argument is the software was authored by or created by the first defendant in the course of his employment with the second defendant, which makes it the property of the second defendant, or if it was assigned to the second defendant or registered in its name. For the moment, we just don't know. Is that the case?
Well, certainly on the claimant side,
yes.
We at the pleading stage, we don't have any knowledge of how MCC was originally created, but our case is that it was owned by the second defendant, and that's based on our understanding at the time, and that's supported by the assignment agreement, which the first defendant purported to cause the second defendant to enter into. And perhaps we can just perhaps we can just look at that. We've referred to it in our pleading at paragraph 26, where we refer to a warranty that was given purportedly by the second defendant under the assignment agreement. But perhaps I could just show you the assignment agreement itself, Your Honour. That's at page 364 of the bundle. And if your honours there, you can see the date of signing in the table is the 30th of November 2021. Your Honour can see in the bottom of the table, the summary of use is transferring IP ownership of 100% from the second defendant to the third defendant. Now, I won't go through all of the terms, but I do want to pick up on the warranty that I mentioned a moment ago. That's at page 368.
Yes.
And Your Honour can see that the warranties that are given by the assignor, which is the second defendant, include that at 4.1.1, the assigner is the rights holder of 100% of the works and proprietary rights to the works, and that's referring back to MCC. 4.1.3, works are original work developed and created by the author. No other persons were involved in the development and creation of the works. So, and just to complete the picture, if Your Honour goes to page 372 of the bundle, you can see that on behalf of the assignor, who, as I say, is the second defendant, that has been executed by the first defendant, Mr. Shehata.
So at this stage, and perhaps it's out of curiosity on my part rather than it probably really mattering at this stage, your case appears to be that this is an admission rather than it's some sort of estoppel by deed or something like that.
Yes, the way we put it in our pleading is that as a matter of fact, the court, it's to be inferred that warranty was true, i.e. that the factual state of affairs it warrants are correct as at that date.
Well, it's a matter of evidence, but you put that as a matter of evidence as an admission rather than it having some greater effect, do you?
Yes, I think that's fair, Your Honour, because as you know, we also seek orders declaring void and or setting aside the assignment agreement. So we put it as a matter of fact that the warranty reflects the factual position. But I think
all right.
We don't.
All right, let's say that probably a diversion of course we didn't really need to do, but I was curious.
Not at all, Your Honour. It's helpful to understand the context. So that's our case in relation to ownership. The first defendant's case is that he created MCC and is its ultimate owner, subject to having licensed the rights to it. First, third defendant, and then onwards to the second defendant. Now, in relation, as I say, it's a critical issue that needs to be resolved in the proceedings. If one then looks back at the categories of documents that are in dispute between the parties, so if Your Honour would look at paragraph 71 of my skeleton again.
Yeah.
The documents which the first defendant has offered to provide are, in my submission, very limited. Just taking a few of them in turn, under subparagraph 1, documents relating to the registration of MCC with Inter-OCO, those are documents which have been disclosed long ago in these proceedings. They're not new documents at all. The purchase order is a reference to a document that's long been disclosed in these proceedings. Copies of invoices, likewise, we have numerous invoices in the evidentiary record. And on the 6th, an attested copy of the assignment agreement. Well, we have the assignment agreement and it purports to be attested by a notary, and that's the document that I've just shown you. So in my submission, these are pretty limited categories of documents. And given the importance of the ownership issue, which the court will need to resolve at trial, it is appropriate for further categories of documents to be included. Now, what we have suggested in terms of the further categories are, as I mentioned a moment ago, the emails that are listed at subparagraph 1 and 2 of paragraph 72 in my skeleton. So the first is emails passing between the first defendant and any employees of the second defendant, HI Egypt, and or the third defendant, other than the claimants, which refer to the authorship and ownership of the MCC software and the MCC rights. So what we're looking at is documents which are identifying the owner, and those will be directly relevant to the issue I've just described. And under subparagraph 2, it's a similar formulation, save that this time it's targeting emails between D1 and customers at D2, HI Egypt, and or D3. Again, it's the same subject matter referring to the authorship and or ownership. Now,
Yes.
the objections that are taken by my learned friend, if I could just run through those briefly. If Your Honour could go to his skeleton at paragraph 122.
Yes.
So the first objection that's made there is that it's unclear, wholly unclear, it said, what's meant by emails referring to the authorship and or ownership of the MCC software and MCC rights. And it's then said that in theory, it would include any document in which the product is being discussed in the context of its marketing and sale to third parties. Now, I don't accept that. That's not what the request is aimed at. An email which merely says, we want to sell you MCC, or markets it, isn't referring to the ownership or authorship of MCC. So in my submission, that point doesn't go anywhere. And the same point applies to sub-licensing.
So your description is intended to, and you would say does, cover express references to ownership, not implied references.
Yes. And actually, Your Honour, one of the objections that the first defendant previously took was that instead of using the words referring to, we had used the words relating to. So in light of that, we amended it. And I think it's clear from that that it's an express reference.
Yes. All right.
The next objection is at paragraph 123. So the suggestion is made there that the claimants haven't suggested search terms which could be used to identify relevant emails of relevant custodians. And my submission on that is that as the party who has the documents, it's really more practical for the first defendant to identify what it considers to be appropriate search terms to sift through the documents. But that's not an objection in principle to the formulation of the request. I mean, usually if there's an issue with search terms, it's something the parties will try and agree with each other.
Yes.
And one would hope that we could do so in this case. And just picking up on the last point made in that paragraph, it said that plainly searches for MCC or Medica Cloud Care will return large numbers of relevant emails. Well, no doubt that's true, but one can obviously think of appropriate Boolean connectors like ownership,
Yes.
own, and MCC. So that's not an insurmountable difficulty. And the final objection at paragraph 124 is to the date range. The date range that we have proposed is 2016 to present. There are two submissions that I make in relation to that date range and why it's appropriate. The first is that the first defendant's own evidence is that he may have developed MCC as early as 2016. And just to make that good, Your Honour, if you could look at page 428 of the bundle. You're in the midst of the first defendant's first witness statement, and the relevant paragraph is paragraph 20, where he says, between 2016 and 2021, I authored MCC. So it's a little unclear as to precisely when he says it was authored, but the earliest date given is 2016. And the range may reflect the fact that software does develop over time. So that's why we've picked 2016 as the start of the range, and it's appropriate in light of that. My second submission is that it's not out of kilter with other date ranges that Your Honour has granted in respect of other requests. And what we're seeking here is relatively narrow in terms of the documents that one would expect to be responsive.
Yes. All right. Mr. Doherty.
Yes, thank you, Your Honour. Just a few preliminary points on the ownership point and what's actually in evidence. There are three things which I think probably complete your understanding of how, at least from the first defendant's perspective, the ownership and authorship is said to arise. The first is, it's important to remember the context in which the clash between the shareholders arose, which was the first claimant's dissatisfaction at being told by the first defendant that Health Insights Dubai was not the rights holder for medical client care. That's really what precipitated the withholding of payments by Al-Khalij and so on. So that's the email where the first claimant says, we at Al-Khalij will not pay Health Insights Dubai anything further. So the operating basis at the point in time that this dispute arose was that Health Insights Dubai was not a rights holder. We also have in the documentary record the agreements provided by the first defendant, first from 2015, which is the document referred to in the pleadings as the licensing agreement. And that's in effect the first defendant licensing for a period of 10 years the use of MCC to the third defendant, the Malaysian entity. So that's 2015, and then 2017 is where you get the partner reseller, which is D3 to the second defendant, so the Malaysian entity to the Dubai entity, saying that you can sub-license this within particular territories. So there are documents which show, as I say, the movement of ownership, and you're quite right to observe that there isn't a positive plea of how Health Insights Dubai came to acquire this information in the first place. But what we would say is, when one is considering the question of whether, in response to this request, there is likely to be further relevant documentation when it comes to proportionality and so on, we would say that really the documentary record which shows ownership is already before the court. Onto the specific bases on which we resist the request. The first is that, in accordance with the requirements of Part 28, the formulation of this request isn't a description of either specific documents or categories of documents with anywhere near sufficient provision to not only identify the responsive documents, but also to try and construct a reasonable and proportionate search for documents. And really, that arises because it's wholly unclear what is meant by and what in the end would be caught by the words emails referring to the authorship and or ownership of the MCC software and the MCC rights. In principle, at least, documents referring to the ownership of the MCC software would probably include any document where there is a discussion about the marketing and sale of that product to a third party, because implied in that is your assertion that you have the rights to distribute the product in that way.
Well, can I stop you there, Mr. Doherty? I haven't canvassed with Mr. Jackson. I might, but Mr. Jackson says to me the intent is that the try to find the actual words of the request. Let's see. Is the request for documents relating to the creation, registration and ownership of MCC and the rights to MCC, or is that just a paraphrase of it?
No, Your
I
Honour.
think that's closer to our request. This one is for emails passing between Mr. Shehata and any employees of all of the second defendant, HI Egypt, and the third defendant, other than the claimants, which refer to the authorship and or ownership of the MCC software and the MCC rights. And then part 2 of the request is emails passing between the first defendant and, instead of employees, you substitute the word customers.
Okay.
So what we're looking for is communications between the first defendant and employees of the 3 entities or customers of the 3 entities, which refer to authorship.
Okay. And Mr. Jackson, when I asked him, said that the intention is to capture emails which expressly refer to the authorship and or ownership, not impliedly. I haven't canvassed with Mr. Jackson, but if the word expressly was to be inserted before refer, that would overcome the breadth issue you've been addressing so far, wouldn't it?
Possibly, but not quite, because I think there are two residual issues with the framing. One is what is meant by ownership in that context, because it's not the first defendant doesn't say that Health Insights Dubai did not have some right in MCC. They did have the right to license it. It's just that they didn't author it. So they had a license to use it in the territories pursuant to the terms of the partner reseller certification.
Well, I would not understand. I'll start that again. Put it in form of a question. If the second defendant had a license giving it the right to use the software or to sub-license it, that would not be ownership, would it? That would be a right to license or use, but it wouldn't constitute ownership of the software, would it?
Yes, well, I suppose the problem with all of these is that it's going to have to require someone to sit and sift and review and decide what treads into an assertion of ownership as opposed to what treads into an assertion of having the rights
I'm sorry, I missed that word. They would have to do what?
Sift through and actually read the content of potentially a large volume of communications. I mean, if one were to try and narrow it down to specifically how did the second defendant come to be a rights owner in the proper sense, I mean, it might well be that words such as, just to go back to it, so emails which refer expressly to the authorship and or say the acquisition or disposal of the MCC rights, that would connote something more than just a passing reference made to a customer of your right to market and sell.
So what did you say there, which expressly refer to the authorship and
acquisition or authorship,
acquisition.
acquisition or disposal of the MCC rights, which are a defined term in the pleadings?
Well, I suppose what the claimants want in addition to all of that is an email which says in terms the second defendant owns the MCC rights or owns the MCC software. That may not be captured by acquisition or disposal.
It's difficult to work out what, I mean, this is part of the problem and really the main basis on which this request is objected to, which is.
Well, what I have in mind is this,
Mr.
Doherty.
Yeah.
Well, I have in mind that if the word expressly is inserted before refer, it will then be a matter for your clients or your instructors to devise a set of search words to uncover those things, and in the statement of truth you will set out the search words that you use to make the search, and I would understand it to be combinations of words such as authorship, ownership, owner, owns. The claimants are putting the matter on the basis of an express reference to those matters, not implicit ones such as marketing and so on. So you can tailor your search words accordingly.
That is one aspect of it, which is narrowing the scope. There are the further objections that we take based on the search that would result being disproportionately burdensome. And there are, again, a few aspects that one I've already alluded to, and Your Honour is probably addressed in terms of constructing a search. If one was to, and this perhaps relates to the previous formulation, because if one was looking at inferences of ownership and you were just searching for MCC or medical cloud care,
Yes.
you'd get lots of. But if we're as targeted as authorship and ownership, that obviously narrows it down to some extent. What's still problematic is both the number of entities and also the number of individuals. So we're looking at all employees and all customers of 3 separate entities, which are not necessarily explained. So, for example, it's not clear why the second defendant or the first defendant would be representing to HI Egypt or to the third defendant anything to do with the ownership. I mean, one could maybe see a point about customers and whether there are any terms that say that they're an owner, but it's not explained why Health Insights Egypt or Health Insights Malaysia are lumped in there if these are about discussions internally to the second defendant about the basis on which it holds its own alleged rights in this particular piece of property. There's also, I think, linked to that, particularly as it relates to Health Insights Egypt, but also the second defendant, questions of whether or not this type of request can permissibly be made by the claimants anyway, because the claimants, of course, particularly when it comes to Health Insights Egypt, are the parties who control that entity. And if what is being sought is correspondence with Health Insights Egypt, then they have control of that correspondence because they're the recipient. And if they're the recipient, then for the purposes of Rule 2817, so that's 2817A and B, requires the party to make a statement that documents requested are not in their possession, custody, or control. So it wouldn't satisfy that requirement of the RDC either.
Have they done that?
Well, one, in my submission, one can take the view that the claimants control Health Insights Egypt and therefore can be taken to be in control of the relevant documents if there are documents passing between the first defendant and Health Insights Egypt.
Yes. All right.
The same point may be made of the second defendant, although one could see that there are at least arguments in those circumstances which the claimants might advance about who's controlling the entity and when. So there are grounds to narrow it on that basis as well, we would say. And excuse me. And yes, the final point really relates to the date range. So on the claimant's pleaded case, the issues that they take are what happened to the ownership of these rights when the dispute arose between the shareholders, which all postdates 2020. And we would say that one could narrow the scope by reference to the date.
I'm not sure I understand that point. The argument that these documents go to is who was the owner of the MCC rights prior to, at the time of and prior to 2020. So why would it be confined to documents after that?
It's insofar as, and it may be there was a misunderstood aspect of the request, but insofar as it was intended to get at the circumstances surrounding the assignment agreement and the
all right.
Yeah.
All right, thank you too. Yes, was there anything else?
Thank you. I was just going to say that, so those are the points we have on that.
All right, thank you. Mr. Jackson, a couple of points. First of all, I hope I'm not verbaling you in saying that it was consistent with your submissions that the word expressly should be inserted after refer.
Yes, Ron, I have no
question. All right. The second point is it's said that your clients control and would therefore have all the documents passing with HI Egypt. What do you say about that?
Well, first of all, Your Honour, it's not an objection that's been taken until oral submissions. It's not referred to in my learned friend's skeleton argument. So it's a point on which I suspect I would need to take instructions. I mean, there has been a dispute between the claimants and the first defendant in Egypt as to the control of HI Egypt. But I'm not sure I can say much more than that.
All right, thank you. I will require the request to be answered. The only addition or amendment I make to it is to insert the word expressly after refer in each of the sub-questions 1 and 2.
I'm grateful, Your Honour. We are then on to the next category. Hopefully we can deal with 4 together, which are requests 4 to 7. I've set up my submissions on this at paragraphs 78 to 80 of my skeleton. There's not actually a dispute on the formulation of these requests, which is helpful. The only dispute, as I understand it, relates to the date range for these requests. But just to give Your Honour some context as to what they relate to.
Can I just check with Mr. Doherty? Is that right? The only dispute is the date range? Yes? Yes, thank you. Yes, Mr. Jackson.
Yes, and it's a relatively modest dispute, but just to give some context to it. As I say at paragraph 78 of my skeleton, what these requests concern is the negotiation and execution of 4 alleged agreements. And you'll see at subparagraph 4 of paragraph 78, one of them is the assignment agreement that we looked at. The purported effect of that was to transfer the MCC rights from D2 to D3. Other than that, one has the licensing agreement dated the 14th of November 2015. So that's an agreement which the first defendant relies upon as saying, by that agreement, I granted a license to HI Malaysia to sell and deploy MCC. And we don't admit that that was a valid agreement or entered into as alleged, and we've put the first defendant to proof in respect of that. Then in terms of the partner reseller certification, Mr. Doherty referred to that earlier. So the purported effect of that was that D3 authorised D2 to resell MCC. And again, in respect of that, we don't admit that that was a valid agreement or entered into on the date it was asserted, and we've put the first defendant to proof in respect of that. And the final agreement is the purchase order dated the 7th of July 2016, purportedly between D2 and D3. And in relation to that, we seek orders from the court declaring both that and the assignment agreement void, or alternatively setting them aside. So that's a long way of saying, Your Honour, that the status of all of these agreements is an issue in these proceedings. Both parties make submissions or take positions as to their status. And it's an important issue because, first of all, the assignment agreement and the purchase order relates specifically to the relief that the claimants seek. As I say, we seek orders declaring void or setting aside the purchase order in the assignment agreement. And secondly, all of the agreements in one way or another, all of the alleged agreements, relate directly to the ownership of MCC. Because
Mr. Jackson, I'm sorry, I'm getting lost with all the papers. Where do I actually find the request?
Our request.
Yes. So
in relation to this request, we sent a letter to Mr. Doherty's solicitors, which you'll find at page 232 of the bundle. And this was our response to objections that were taken by the first defendant to our requests. And this, in essence, sets out a modified request that we were putting forward.
If it helps, the original request, I think, start at page 217.
117.
Yeah.
What you're looking for is the schedule.
Yes.
Yes.
And then so I go to 234. It says, so that sets out so at 234 at paragraph 5A, is that the original request? All documents between D1 and D3 relating to and so on?
Correct.
Right.
And that's repeated for requests for request 5, 6, and 7.
Okay.
And those formulations haven't been objected to, but what's been objected to is the date.
And you wanted 3 months each side, and Mr. Doherty says 1 month.
Exactly so. And it may seem like a relatively modest dispute, Your Honour. The reason I say 3 months.
Well, I hope I must say I'm awfully tempted to adopt Solomon's approach, cut it down the middle. But
well, if you're honest minded to do that,
unless there's some magic to 1 month or 3 months, it's.
I would accept there's some subjectivity inherent in it. What I would say is these are critical issues in the proceedings, and yes. 3 months either side in respect of documents relating to the negotiation and execution of agreements is not particularly onerous. What you would expect there to be is documents between the relevant counterparties negotiating and then providing the signed versions. So that's why I say 3 months is appropriate.
Yes. All right, Mr. Doherty. Why is 3 months not right?
Yes, one, I suppose it's a compounding factor. There are 4 of these. Every time you expand out a month, you're doing that times 4. So you're turning what on our offer, I think, is 6 months worth of documents that need to be searched through to about 2 years. So just on a pure numbers basis, it's about limiting to what's reasonable and proportionate. And when one looks at it in those terms, you just have to look at what the justification for expanding the terms, the search period out is. What's been offered doesn't really offer a rationale for creating a wider window. So what's said is that the question in proceedings is whether the alleged agreements were genuine documents and were validly executed. If the case that's being put is that these were a concoction after the dispute arose, such that they're fabricated contracts that were actually executed sometime in 2021 or 2022, expanding that window out is not going to do anything at all. It's going to be searching documents for something that, on the claimant's analysis of the relevance of these documents, wouldn't be there in the first place.
I suppose sometimes, Mr. Doherty, even the absence of something is evidence.
Well, indeed, but I suppose what might be said is that if we search 1 month, if we search the 1 month window and don't turn up with anything, then it's ultimately us who's going to have to answer that question concerning the legitimacy of the document. But the point is, the question of whether it has been executed, as it says, on the date it bears, would require one to disclose documents on the date that the contract was executed. The surrounding stuff is not going to inform that question at all. And so if one is looking at the reasonableness and proportionality, we say that from the outset, we've never objected to these documents being relevant. We just said, well, we don't know that there are actually going to be documents that are responsive to this, but in any event, we will search, and we'll search in these time periods, which we think is reasonable.
All right, thank you. This is a subjective question about what is reasonable and what is proportional. Given that they are important matters, I will require it to be for 3 months each side. What's next, Mr. Jackson?
Your Honour, we're then on to requests 10 to 11, which are the penultimate requests. I've set out my submissions on this at paragraphs 81 to 84 of my skeleton, and you'll see the formulations at paragraphs 81 and 82. So request 10 is for emails and or letters between D1 and or D2 and D2's auditors relating to the preparation of D2's audited financial statements, and also audit reports prepared by D2's auditors. So that's essentially audit documentation. And request 11 at paragraph 82 is bank statements for any bank account held by D2. And our proposed date range is the 1st of January 2016 to present. Now, the only objection that we understand the first defendant makes to this is that the first defendant says that the claimants are now in control of documents, of the documents, because the second claimant has been appointed as the general manager of the second defendant. And that's my learned friend skeleton at paragraph 134. Now, our evidence on this is set out in Ms. Roshan's fifth witness statement. If Rona could turn to that, the relevant page is page 255. And it's paragraph 7 of her fifth witness statement. So as I said earlier on, it's common ground that up until at least May 2023, the first defendant was responsible for D2's day-to-day operations and management. It's correct that he was replaced by the second claimant as the general manager. But as Ms. Roshan sets out there, our evidence is that the claimants are still unable physically to access the second defendant's offices due to him failing to engage in a handover process. And they are unable currently to verify whether they have access to all of the documents of the second defendant. Now, it is true that we've been able to access some documents, and in relation to that, we do have some bank statements in the bundle that we've been able to obtain from HSBC. And I'm just going to show you one of those briefly, Rona. It's at section I, tab 7.
Page.
And the relevant page is page 2114. So the bank statement obviously starts earlier, but this is a bank statement from relating to HI Dubai with HSBC, and the branch is in Dubai. And Your Honour can see on this page, 2114, the statement date is the 31st of August 2023. And you can see that in fact, you can't see from this page, but from the previous page, Your Honour can see that the currency is USD. And if we focus on the middle half of 2114, Your Honour can see that there's, on the 29th of August 2023, so after the dispute concerning HI Dubai had erupted, there is what's called a temporary transfer of 400,000 US dollars to Nasser Shehata, and it's stated to be a temporary transfer due to company account closure. And then under the 31st of August 2023, there's a further $145,000 transferred to Mr. Shehata. So this is evidence that we've recently been able to obtain. And as I say, we're not able to access all of the documents or verify that we have all of the documents relating to the financial condition of the second defendant. But insofar as we have been able to obtain documents, those documents, in particular this bank statement, do call for an explanation. And we say that's relevant for Your Honour to take into account in terms of whether further bank statements in relation to this request should be provided.
What issue in the case does it go to?
Well, Your Honour, as Your Honour is aware, we do seek an injunction against the second defendant, sorry, the first defendant. That was sought in the context when he had not yet been effectively placed. So I can see that, strictly speaking, it's relevant to the pleaded issues. But although that head of relief will need to look at whether that needs to be pursued. But more generally, it's relevant to as a response to the first defendant's case against my clients, which is that they have diverted revenue from D2, they're acting against the interests of D2, and they've breached their director's duties. And it will also be relevant in the context of the unfair prejudice claim that he seeks to bring, where he says effectively I've been excluded from the management and decision making of the second defendant, when based on this selection of evidence, it appears that he's dissipated funds from the second defendant. So that's where it may come in.
All right.
So returning to the request, we say that these aren't documents which are in our possession at the moment, and they are documents that should be provided, in particular in relation to the bank statements.
So Doheny?
Yes, Your Honour. This is a request, the history of which is that it's been narrowed from, I suppose, what one might call an extraordinarily wide start. The original request was for all documents relating to the financial health and position of the second defendant, including but not related to, and then it includes audit report, bank statements, and so on, which was objected to, we say quite rightly, on the Tilleen grounds, which is extraordinarily wide. It's unclear what was meant by the financial health or its relevance to the case. The problem with the reformulation is it's impermissible, but for a completely different reason. So where before it wasn't relevant or material, let alone reasonable or proportionate to the issues, now the problem that the claimants face is the Rule 2817 problem, which is if you're going to make a request for documents, then you have to show that they are not in your possession, custody, or control. Now, the position advanced, as I understand it, by the claimants, effectively deals with one aspect of that, but the concepts of possession, custody, and control are disjunctive. You only have to have one in order to establish that you have it. So when they say that they can't access the offices, that might mean it's not in our custody, even if it's correct, but it doesn't mean that the documents are not in their control. And that comes back to the Berkeley Square case, which I referred to in my skeleton argument. But really what one is looking for here is that there needs to be, the threshold is as low as there being an arrangement or understanding, that the holder of the documents will search for relevant documents or make them available to be searched to the person requesting them. Now, the way that the request has been reformulated is, please provide us with information exchanged as between the second defendant and its auditors and its banks.
Sorry, can you take me again to where I find the request?
Yes, the most straightforward place might be Mr. Jackson's skeleton at paragraph 81 sets out the reformulated version of what's sought.
81.
Which is at page 18 of the skeleton. I'm afraid I don't have the overall bundle reference because I've got it.
Okay, I've got it here. Okay, emails and or letters between D1 and D2 and so on.
Mm-hmm. So it's the second defendant's auditors and it's the second defendant's bank statements. The second defendant, it now ought to be uncontroversial, is controlled by the claimants and the general manager is the second claimant. And when one is looking at the Berkeley Square assessment of what control means, i.e. an arrangement or understanding, there's nothing to stop the second claimant from writing to the auditors saying, can you please provide us with copies of our correspondence? Nor is there anything to prevent them from writing to the bank saying, please give us our bank statements. There is an arrangement or understanding in place, and that means, to all intents and purposes, they have control of the documents that they're now requesting. So they don't overcome the threshold requirement in Rule 28.17, and they're seeking documents from us, which they have access to themselves.
So what they want is emails or letters with the auditors and audit reports. And so you say they can get that from the auditors.
Yes. And same for the bank statements. And in fact, it seems they already have the bank statements, or at the very least they've got, well, you've been referred to the bank statements with HSBC being accessed. And again,
Well,
that's not.
Mr. Jackson says they've got some. Perhaps I would need to ask him a bit more about that, but
I think my reading of it from the skeleton argument is they say, well, we've got the HSBC statements, but we don't know if there are other bank accounts which exist, which is a speculative basis for putting forward that sort of request. They have the HSBC statements, and if there were intercompany transfers, they might have been able to point to one of those to show that it existed. But the first point I would make is that there's no basis for them to think that that exists. I suppose the second criticism that might be leveled at that is, if what they're asking for is, do other bank accounts exist? That's, as Mr. Jackson put it earlier, a request for information, not documents. But in any event, if there were to be an order reflecting bank statements, that the HSBC statements ought to be carved out of it in any event, because quite clearly there's already control over those. So the residual rub, it seems, of what they might properly be described as having control over would be bank statements other than HSBC, but they have control of the auditor documents, and they have control of the HSBC statements. I don't know that there's a point when it comes to relevance, really. I mean, we suggested there's some dissipation of funds, but I mean, as it stands, that's not a pleaded case. There's no assertion of the first defendant having dissipated funds from the company. The pleaded case is about what happened to the property rights.
Your Honour, just briefly on the bank statement, if I may.
Yes.
The HSBC account is referred to in the assignment agreement. So we are aware of HSBC at least through that. What we do not know, as I set out in my skeleton, is what further bank accounts exist. Now, Mr. Doherty's response to that was to say, well, it's speculative to say that they do. But in relation to requests that his client made, which Your Honour granted in respect of his application, I raised the same similar objection, at least, in relation to the defendant not having pleaded any identified entities to which profits might have been diverted. Simply because we're not in the possession of the information, that doesn't mean that further bank accounts don't exist. And
on that point, Mr. Jackson, should the HSBC account be carved out? You've got that.
Yes, I wouldn't object to that, Your Honour, because we are in contact with HSBC, it's fair to say. So I wouldn't object to that. But in relation to other bank statements, I do say that those should be included. But some of the points made by Mr. Doherty seem to be that if one has a legal right to possess the documents, even if one doesn't know where they are, then that's sufficient for possession, custody and control. And that, in my submission, it would lead to the court making an order that's detached from reality. I mean, if we don't know where to find the documents, it's very difficult to see how we can be treated as having possession, custody or control over them.
Yes. All right, thank you. I will require those requests to be answered, with the request 11 being amended to exclude the HSBC account. All right, what else, Mr. Jackson?
Happily, we're on to the last set of requests, Your Honour. So these are requests 12 to 15. In terms of the formulations, I've quoted those at paragraph 85 of my skeleton.
Yes.
Just to explain briefly the context to these requests. All of them relate to, in broad terms, the financial condition of D3 and profits and gains it may have received. And one can see that from request 12 is for financial statements, request 13 management accounts, request 14 emails between the auditors, some audit documentation we were just looking at, and then request 15 bank statements. And our proposed date range for that is January 2016 to present. Now, the reason why we say these requests are important is because our case is that via the assignment agreement and the purchase order, which we seek an order from the court setting aside, D1 has profited via D3. So in relation to the assignment agreement, our case is that by purporting to transfer the MCC rights from D2 to D3, ultimately D1 is the person who profits from that, because it's common ground that D1 is the managing director and sole shareholder of D3. And just to make that point good, Your Honour, if we could go to page 11 of the bundle, to the particulars of claim. So it's section A, tab 3, page 11.
Yes.
You'll see we plead there in the second sentence, the first defendant is and has at all material times been the sole shareholder, director and general manager of the third defendant. And then if Your Honour goes to page 20 of the bundle, we can see the response in D1's defence and counterclaim at paragraph 11, where he says, save that the first defendant is the managing director and not the general manager of the third defendant, paragraph 3 is omitted. So there's no dispute on the pleadings that he is the sole shareholder, director and managing director of the third defendant. So that's why the documents we seek are relevant here. And the specific relief to which they will be relevant is the account that we seek from D1. And Your Honour can see that in the particulars of claim at it's in the prayer at page 17 of the bundle. And this obviously follows on from the substantive pleas set out earlier, where we say that the assignment agreement and purchase order are to be set aside. At paragraph 4 of the prayer, we seek an order directing the first defendant to account to the second defendant for any profit, gain or benefit realised as a result of the purchase order and or the agreement.
So why do you need, I'm sorry, maybe it's getting late in the day. I don't still don't understand why you need all the bank statements, etc. They will be required if the account is required. They will be required in taking the account. But why are they needed before that?
Yes, because the accounting exercise, I mean, in terms of what we'll be asking the court to do at trial, we'll be asking the court to take an account at trial by reference to documentation. Yes.
Well, I must say that's not something I had envisaged.
Well,
I had envisaged that this was a
it goes back
to a two-stage process. First of all, an order for an account, and then subsequently taking the account. I must say it probably practice varies, but that's always been my practice to first of all determine whether an account should be given, and then if so, order the account. Not trying to take the account in the course of an action which is ranging over a wide range of matters and factual matters to be determined before right to an account is taken, a right to account is established. I must say I hadn't read, now when I read your claim again, it says an order directing the first defendant to account. I hadn't read that as meaning anything other than if you're successful, there will be an order that the first defendant account to the second defendant, not that the account would be taken in the course of the trial, determining whether or not you're entitled to an account.
Well, I think there are 2 points I'd make in relation to that, Your Honour. The first is the way the DCC regs. I know you've seen before, although probably at a previous hearing, the way they're framed. So if we could just look at those, the relevant subsection is 79.6. That's at page 324 of the bundle.
Yes.
So that sets out the relief that the court may grant. And
Yes.
it essentially two limbs to it, the setting aside and then
Yes.
Now, I accept that in theory one could divide those, but neither party in these proceedings has suggested that there should be some form of bifurcation.
Well, I'm not sure that what the bifurcation you're referring to is. The two forms of relief, if you like, which are referred to, are first an order setting aside the transaction.
Yes.
And then secondly, directing an account. Now, I have not understood, sorry, I'll start that again. What I said to you was my understanding of the way in which the case was presently framed is that that's what you are seeking. That is, first of all, an order setting aside the transaction, and secondly, an order directing that an account be taken, that the director account to the company, not that there should be one hearing about whether the transaction should be set aside and then a second hearing about whether or not the director should account, but rather there be a hearing whether or not there should be an order setting aside the transaction and directing an account, but not that the account be taken in the course of the trial.
Yes, I see the point Your Honour is making. It's certainly, I can say that from our side, we proceeded on the basis that the account would be taken at trial. And that is why in relation to case management directions, we sought a direction from the court that the parties have permission to adduce expert evidence in the field of forensic accountancy in relation to the quantum of an account. Your Honour may remember that was case management direction.
But the way in which an account proceeds is that if the director is ordered to account to the company, the director must draw up an account. He must give an account stating the profits or the receipts he's made, any expenses, and so on. And then there is, and then you object, if you wish, to items in the account and so on. That's the way an account is, in my experience, that's the way an account is taken. It's not some sort of inquisitorial proceeding going on during the course of a trial. The director, an order that the director account means just that. He gives an account and then it's open to you to object to items in the account.
Well, Your Honour,
that's the way I understood an account. That's the way I've always taken an account, and I don't know, experiences are different.
Yes, experiences do vary. I mean,
but how else can it run during the course of the trial? The director has not put forward an account. He denies that he has to account. He's not put forward an account. So how is an account taken in the course of a trial?
Well, stepping back a moment, the sort of traditional account, if I can call it that, is exactly as Your Honour describes, that, for example, we have a trustee who is required to account. They draw the account and then it's gone through. There are cases, certainly in my experience, where an account of profits is being ordered. And in relation to that, the parties adduce expert evidence on quantum to determine what the quantum of the account is.
That's so, but again, the first step in an account of profits is usually for the accounting party to set out his account. Then, say, other party can object to it and expert evidence can be led and so on. But I've got difficulty in seeing how an account is taken.
Well, it
other
may be
than that, it's not a case. I mean, it's quite different, seems to me, than a claim, whether it be for damages or some other sort of relief, where your claim is for lost profits and you bring forward evidence of what your lost profits are. I mean, that's a common process where if you've claimed that some wrongful action has caused you loss, you say you've lost profits and you lead expert evidence as to your loss of profits. But the words here account to the company for any profit, and that seems to me to give rise to what you characterise as a traditional account.
Well, it may be something that, without wishing to shy away from Your Honour's point, that the parties need to give further consideration to.
Well, very much so, and that's why I'm going through the matter.
Yes.
Very important that we know what it is we're going to be trying.
Yes.
I might ask Mr. Doherty if the defendants have turned their minds to this question at all.
Well, they also seek an account, so
yes, quite.
That is.
And I had approached that in the same way, but Mr. Doherty, how do you see the matter?
I think probably the short answer, the fair answer is I had probably proceeded on the basis that Mr. Jackson had been proceeding. But that doesn't mean that there's not a valid question as to sequencing that needs to be addressed, as Your Honour points out, and it may well be that that is something that the parties need to discuss.
Well, I think it's not perhaps saying sequencing is a perhaps shorthand way of putting it, but it seems to me there are two quite different concepts, two quite different forms of relief. One is where a party claims loss in the form of loss of profit, or in an equitable case that the other party disgorge profits which they have made, and that might be approached by the parties putting forward, as in the usual way, evidence of what they say their loss is and producing expert evidence in support of it and so on. But that seems to me both a different process and a different form of relief than a party being required to give an account, which, as say in the ordinary, I think what Mr. Jackson characterises as the traditional method of account is just that the accounting party, draws up their account in which they will have a list of items of receipts and outgoings and a balance, and then the matter follows in the usual way with the receiving party objecting to items, and then there may be evidence required and even expert evidence in relation to all that. But it does seem to me they're two quite different processes, and because it goes back to what the relief being sought is. Is the relief loss damages for loss of profits, or is it an account of profits, which is, I'm probably repeating myself, a different form of relief? Now, if I think we're not going. I think having become aware of the issue and or created it for you, we're not going to resolve that tonight, or this. I think still the morning, or I think it's just still the morning for you. All right, but it does raise the question, though, Mr. Jackson. Does your request 12 to 15, do they relate to this question of what the profits are, and if the matter was to proceed on the basis that the question for trial is whether there is to be an account of profits, and that if that order is made, the account is taken at a later time, would those requests then be relevant to the second stage, that is the taking of the account, rather than at a trial at which the question is whether an account should be taken?
Yes. So if I can take those points in reverse order, it's clear in my submission it would be relevant to the second stage.
Yeah.
As to the first stage, I do say that it would be relevant to the issues that would arise at the trial. And in particular, if I could just take Your Honour through a few points in our pleading.
All right.
So first of all, in the particulars of claim, page 15 of the bundle, paragraph 27.
Yes.
So one of the points we make there in respect of the assignment agreement is that the first defendant had no actual authority to enter into the agreement on behalf of the second defendant. And we say that the terms of the agreement were contrary to the interests of the second defendant, in particular, in circumstances where the economic value of the MCC rights was significant. And the documentation that's sought in relation to requests 12 to 15 would be relevant to that issue of whether the economic rights to MCC were significant. Because if, on the first defendant's case, D3 has been exploiting MCC as a licensed right holder, there will presumably be evidence of the money it has received via MCC, and that will be contained in requests 12 to 15.
So are you saying because the receipt of funds would be evidence that the MCC rights had economic value? Is that what you're saying?
Yes. So the price that's purportedly paid by the third defendant for MCC under the assignment agreement is $500,000. And our case is that is very insignificant compared to the actual economic value of MCC. And that's one reason why we say it's contrary to the interests of D2. But it would be relevant for the court to consider funds which were received by D3 in respect of MCC, and that those funds will be apparent from the information that's requested under request 12 to 15.
I see.
It goes beyond the account. And the same point arises in respect of the purchase order, which we deal with at paragraph 16(1)(a) of our particulars. That's at page 13.
All right.
And it's the same point on economic value, but in the context of the purchase order. So it is relevant to the relief that we see at the trial separate to the account.
Yes. All right. All right. Was that all you wanted to say, Mr. Jackson?
Yes, Your Honour.
All right, Mr. Doherty, what do you say about all of that?
Thank you, Your Honour. I feel it would be remiss to go through a hearing like this without at least one party getting to throw out the term fishing expedition. So I'll next. We say that the claimants haven't really sought by reference to the pleadings to explain the relevance of these documents. It's not disputed that Mr. Shehata is a director of the third defendant. The pleaded case is that there are these two agreements, the purchase order and the assignment agreement, which are voidable as a consequence of the alleged undisclosed conflict of interest. But if one looks at what the pleaded case is getting at, so page 15, paragraph 24, what the validity or not of these agreements
Yes.
is concerned with is whether the price stated in those agreements, to the extent that they're relevant at all, is that they undervalue the MCC rights or work done. And again, in paragraph 36, which is on page 17, it makes the same point. So this is in relation to both agreements, but to the extent necessary, the claimants will say that the price agreed in the agreement was substantially undervalued the MCC rights and the work done. So the pleaded case about these transactions is an alleged undervaluing of the MCC rights. So in other words, the MCC rights have been given away for very little when the second defendant should presumably, on this analysis, have been paid considerably more if it was disposing of those interests to a third party. We, of course, know what the amount of the purported disposal was, because that's set out in the assignment agreement. So the question beyond that of what profit, gain, or benefit there is only going to come down to what the valuation of the product is itself. So how valuable is MCC, the software, as an asset? And if you take $500,000 off that, that would give you the idea of what the profit, gain, or benefit is. Now, that amount is not going to be recorded in the documents that are being sought. That's not how one is going to get the answer to what the undervaluation is. The way one would get an answer to what the value of the product is would be to get someone who knows about these things to opine on how valuable an asset like this is in reality. But it's not going to be in audit reports. It's not going to be in bank statements or accounts, and it's not going to be in the third defendant's financial statements. So the documents being sought, not only, as Rene has pointed out, they don't necessarily go to the liability issue, but in my submission, they don't actually even go to the quantum issue, because this isn't like the first defendant's case, for example. This isn't about dissipation of revenues from one company to a series of other companies where one might see those revenues being reflected in bank accounts or in financial statements. Here we're talking about, in effect, the value of a product, which isn't going to be recorded in those documents.
But so far as Mr. Dougherty, so far as the relief concerned, the relief includes a claim. I'm trying to put it without, trying to put it in a way that avoids the question of whether it's to be quantified at trial or at a subsequent account. Leaving that question aside, the relief is for any profit, gain, or benefit realised. So that's looking not to the value of the rights, but to what profit or gain the defendant made from it, which would require an examination of these documents, wouldn't it?
Well, I don't know that it's necessarily that clear, because it's not even really pleaded that what Health Insights Malaysia is doing is, for example, taking the product into Saudi Arabia or the UAE and marketing it and generating profit from it. It just says that you've assumed ownership rights when you shouldn't have. So it's not pleaded that in that sense Health Insights Malaysia is competing with Health Insights to buy. So it's not necessarily relevant to a pleaded issue in the case, we would say. And there's no suggestion that there ought to be an account for any profits made by HI Malaysia, because it's not pleaded that they have actually generated those revenues in the first place.
Well, that's a relief they claim, isn't it?
Well, I don't think that
you haven't sought to strike it out on the basis that there's no basis for it.
my reading of the case as pleaded is that you're accounting in effect for the giveaway, so the giveaway of the property rights. So to the extent that Health Insights Malaysia has benefited to the tune of acquiring a valuable piece of property, you must account for that. But I don't think it's being suggested that, or pleaded at least, that Health Insights Malaysia is taking that property and using it in competition to generate
See.
revenue. Otherwise, would go to Health Insights Dubai. That's certainly, if it is in the pleadings, I haven't seen where it is in the pleadings, and I'm sure Mr. Jackson might be able to point it out. But that's certainly the first defendant's understanding of the case. And in any event, as we say, bank statements aren't going to tell us what the value of MCC is. And given that lack of relevance and materiality, when one looks at actually what the core pleaded issues really are, it's unduly burdensome to make sweeping requests for the third defendant's documents. That's the first main point. The second main point you'll have from my skeleton anyway, which is as it relates to the position of the third defendant in proceedings, that's still an issue that's not decided, and that making an order like that would be premature.
Yeah, now remind me, I'm sorry, I forgotten about it. Where are we at on the jurisdiction issue?
Well, I think we're awaiting judgment on
right. Well, I'd say I'm afraid then I've forgotten this matter. Am I not awaiting any further submissions from the parties? It's all, so far as you're concerned, there are no further submissions to come, and you're just waiting for a decision. Is that right?
Yes.
I see. Well, I'd better decide that very quickly then. I must say I've would appear misunderstood that there was to be some further submission from you, but that's not right, Mr. Doc, from what you tell me, Mr. Doherty.
Mr. Jackson tells me I'm wrong. That's the position. And so what we say is, the ordinary course, this is a request which would potentially be contingent on the outcome of that in any event.
All right.
So one ought not to make orders about the third defendant until its position in proceedings is known.
Yes. All right.
About that.
All right. Thank you.
Your Honour, if I may, I've just had
yes.
3 points in reply to that. The first is that in relation to the relief that we seek, we are seeking an account of any profit, gain or benefit realised as a result of the purchase order or the assignment agreement. And that was the part of the prayer I took Your Honour to earlier. So that is not limited.
And Mr. Jackson, when you say any profit realised, does that mean by the first defendant or by anybody?
Well, the first defendant is the one who's required to account for it.
Yes.
The regulations don't impose or don't prescribe who the identity of the person who is profited from is.
What do you say is your plea?
Well, as I say, our case is that the first defendant has profited from it because
the first defendant has.
Yes, because he's the sole shareholder and the managing director of the third defendant. And
so
we say
you mean indirectly?
Yes.
It's your case that the third defendant has profited and the first defendant has then profited by way of whether it might be dividends, receipts, whatever, through the third defendant. Is that your point?
Exactly. Okay. So. And in fairness to us, and it's the point that Mr. Doherty raised in the context of his application and in my submission, source for the goose, source for the gander, that in relation to this aspect, we don't have any insight into what was going on with HI Malaysia because my clients have never been directors.
And on the second point, way in which you put it, Mr. Jackson, that profit, gain or benefit, I think I might be unfairly characterising what Mr. Doherty said, but I thought Mr. Doherty was saying the profit, gain and so on was the difference between, on the one hand, what the third defendant paid for the rights and on the other, what the rights were worth. But is that the way you put your claim, or do you put it differently, and if so, how?
Well, we don't accept it as limited as that.
Yes.
Mr. Doherty seemed to be suggesting that the way one values MCC, and the only way, is by valuing it as an asset. Now, that my submission is a bit of an oversimplification because obviously assets can have revenue streams. And in valuing the asset, it's relevant to take into account the revenue streams, for example, in relation to a product that are being generated. So
but Mr. Jackson, you can either value the asset, and as you say, there are different methods of valuation. one method of valuation is a cash flow, and in any event, probably many approaches would take into account revenue to be derived from the asset, but that's still a valuation of the asset. A different question is profits that are made from the use of the asset, and that's a different matter. I'm not sure now what it is you're claiming.
Well, in relation to one issue is that we don't know how exactly it's been used by D3, but our case is currently formulated is that if D3 has used MCC to generate revenue, that's as a result of the license agreement, and that's relevant, and that's part of the quantum of the account.
Yes, but the quantum of the account, but the account, again, in what you call traditional terms, what I call what an account is, it involves revenue and outgoings, not asset valuation. They're two quite different matters. One is valuing an asset, and as we've said, in the course of that, the revenue stream to be generated is relevant to the asset value. But a different matter is to look at the profits that are made from it, not as a step to valuing the asset, but as recovering the profits that were made from the asset. Now, I don't know which it is that you're claiming. I thought it was the latter, but I'm not sure now.
Yes, I mean, it's the latter is what we've advanced our case so far. I've obviously taken on board your Honour's point about the nature of an account, what I call a traditional account.
Yes.
But even if one's under the first scenario, it'd be relevant in that context, in my submission, to take into account what revenues have been generated. The only other point I would make, Your Honour, was into the jurisdictional point. I think what happened there is that Your Honour heard the jurisdiction application set aside went part heard, and the parties were to come back, but that ended up being settled. So that's how things played out.
Yes, thank you. That does explain it.
Yes.
But again, I think Mr. Doherty is of the view that both parties have made all the submissions they have to make on the jurisdiction question, and it remains for me to make a decision. Do you agree with that?
Yes, I do agree with that.
All right.
I was just providing some context as to why.
Yes, I'm glad, because at least it gives me a reason for why I didn't deliver a decision at the time, which I'm grateful for.
Yes, I think in fairness, the parties probably should have notified the court. But in relation to the substantive point that he makes on jurisdiction, the argument advanced is that the fact that the court has not yet handed down its judgment on D3's jurisdiction application means that the court can't or shouldn't grant any of these requests. And in my submission, that simply doesn't make sense.
No.
First of all, there are many cases, which no doubt Your Honour would be familiar, where the court does make document production orders against a party, and those documents involve someone who is not a party to the proceedings, and over which the court has not said it has any jurisdiction. It's not a barrier. And in this case, in circumstances where D3 is owned and solely controlled by D1, in my submission, the documents are plainly within D1's control.
Who do you seek the document? Who do you seek the order against?
Against D1.
Yes.
Yes, because we say it's sufficient. The documents are within his control.
Yes.
I've cited in my skeleton the North Sea Ventures case, which one-man band companies, essentially.
Yes.
And that's all I want to say, Your Honour.
Well, thank you.
Sorry, I was interrupted. I need to give you just a reference to the pleadings, because I was in relation to a question you were asking about the pleaded basis, which is paragraphs 35 and 36, which is page 16, bottom of page 16 and top of page 17, in relation to the question of whether what's being advanced is it the value of the rights or is it the profit extracted from the rights?
So it's for any profit gain or benefit realised as a result of the agreement. Yes.
And then it's paragraph 36, which follows on.
Yes, well, I must say that's about as clear as mud, the way I look at it at the moment.
Well, I do have a response to that, Your Honour, but it may not be relevant for the purposes of these requests.
No.
I mean, I'm happy to...
Look, the view I take of it is this. I'm not persuaded that requests 12 through to 15 are relevant to, if I can characterise it, the questions of liability, but they are relevant to the questions of profit gain or benefit realised. Now, that raises squarely for me the question of what is part of the proceedings leading to trial. And to put that more expressly, if at trial the court is to determine, in addition, first whether there ought to be an order setting aside the agreement, secondly whether the first defendant should be directed to account to the second defendant for any profit gain or benefit realised as a result of the agreement, and thirdly, if so, the quantum of that profit gain or benefit realised as a result of the agreement, I would order that the first defendant answer that request. If, however, the question of the quantum of any profit gain or benefit realised as a result of the agreement is not to be determined at the trial, but is to be determined only if and when the first defendant is directed to account to the second defendant for any profit gain or benefit realised as a result of an agreement, I would not order the first defendant to answer the requests at this time, but would only order that if and when the first defendant has been ordered to account to the second defendant for any profit gain or benefit realised. Where that leads me is this, that I will adjourn the question of requests 12 to 15 at this time. And that takes me to what is, I was going to say, a more important, certainly at least as important a question, and that is what is to be determined at the trial. And that's a matter which it is important that we should now determine. What I propose is that the parties should confer about this matter, because it appears to me that that's not a matter which has been addressed at this time. And to try and be clear about what the issue is, and perhaps in a sense I'll repeat what I said a minute or two ago, the relief claimed by the claimants set out in paragraphs 35, 36 and in the claim for relief in relation to the agreement in relation to purchase order and the agreement, has three elements or aspects to it. First of all, whether the agreement or the purchase order should be set aside. Secondly, or in the case of the purchase order, declare void. Secondly, whether there should be either an order directing the first defendant to account to the second defendant for any profit gain or benefit realised as a result of the purchase order of the agreement. And thirdly, if so, what the quantum of that profit, gain or benefit realised is. Now, the matter which I need to determine is whether the whether the third question is part of the trial or is only to be determined if and when the court determines that there ought to be an order that the first defendant account to the second defendant for any profit, gain or benefit realised as a result of the agreement. It appears to me that the question has not been expressly addressed by the parties at this time, and I now want the parties to consider that and confer about it. If I can say or really repeat to the parties, I had understood that the relief being sought was or is an order for an account which would result in a subsequent taking of an account if the order was made. If that's not so, and the question of the account or the quantum of the profit, gain or benefit realised as a result of the purchase order or agreement are to be determined at trial, for the moment I have difficulty understanding how that would be done. And that is because of the nature of an account. An account is where the accounting party is required to state the profits or the revenues received, the outgoings made, and therefore the gain. It is difficult to see how that might be done in the course of a trial where the defendant denies that it is obliged to account and therefore doesn't give a statement of the revenues it has received and outgoings it has made. Seems to me that what I understood was being put by Mr. Jackson is really that the court would be asked to quantify what in effect is a claim for damages, or to quantify the profit, gain or benefit realised as a result of the agreements, not that the defendant should give an account. Now, I appreciate that the regulations are almost they present a form of relief not generally known in probably England or Australia in the way it's put. So it might be that what is required by the regulations is that a determination of whether the defendant is obliged to account, and at the same time that there should be a quantification of that profit or loss. But that's something I want the parties to expressly address, and if so, how that's to be done. Is it to be simply, as Mr. Jackson, I think, envisages, that the parties each lead evidence as to the profit, gain or benefit realised? But I do want the parties to now inform me, not now, to confer and then inform me whether that quantification exercise is to be undertaken at the trial, rather than it being only undertaken if the court has determined there should be an account. what I do envisage now is that, as I say, I had overlooked the pending or outstanding jurisdiction issue. I will now give consideration to that and give you a decision. I will then list the matter for a further directions hearing in which you can address me on, first of all, I suppose it depends on what the decision on the jurisdiction question is, what, if any, implications there are of that, and then secondly, on the questions that I've raised with you about the whether there should be a taking of account only after there's been a determination of whether there is a right to an account, or whether there should be a quantification of those profit, gain or benefit in the nature of damages. Before I go to setting that, Mr. Jackson, Mr. Doherty, do you want to say anything about that course which I have mapped out?
No, Your Honour, it sounds very sensible from our perspective.
Mr. Doherty? I think that the first thing, it's dependent upon me giving you a decision on the jurisdiction question, which I'll endeavour to do as quickly as I can, but as always, there are always other demands. I think probably the only sensible course I can take is in relation to request 12, the complainant's request 12 to 15, I'll adjourn those requests to be determined at a later time. And then when I have delivered a decision on jurisdiction, ask the registry to liaise with you to fix a directions hearing to follow. I would hope, and in saying that, I'm encouraging you to be available as quickly as soon as possible after that jurisdiction decision is handed down, so that we can address these questions. The trial, I think, is listed, is it September, October, I think?
Yes, Your Honour.
Yes.
September.
Yeah.
And as we all know, that's not a lot of time when these sort of things are in the air. So once I've given that decision on jurisdiction, I'll ask the registry to contact you, and I urge you to make yourselves available as soon as you can after that. All right, so for today, I've indicated the orders to be made on the defendant's application. Mr. Doherty, you will cause a minute to be drawn up of a draft order and confer with Mr. Jackson about that, and then send it into the registry. Mr. Jackson, you will draw up, of course, to be drawn up an order on your application. So far as request 12 to 15 are concerned, that is that those requests should be adjourned to a date to be determined. Now, a question always which counsel are always much more anxious to talk about than courts is the question of costs. I will tell you my provisional views and then let you say what you wish. My provisional view is that there's a measure of success and failure by both parties. Secondly, these matters are in the nature of case management. All of that leads me to the view that the costs of both applications should be costs in the case. Who's going to try to persuade me that I should now spend more time listening to some different argument?
I'm happy to go first, Your Honour.
I'm sorry?
I was just saying I'm happy to go first if it insists. Broadly, we make 3 points. I'll try and deal with them briefly. First is that when it comes to the nature and extent of the disputed issues, the first defendant should be seen as the more dominantly successful party. Second, the claimant's approach to this hearing is what caused most of those costs to be incurred. And the third is that the first defendant's position was reasonable and sought, so far as was possible in this sort of case, to be cooperative. And just dealing with those points in turn. On broader success, as my learned friend said, the meaty part of this was the first defendant's application. That's what consumed most of the oxygen and submissions in preparation for the hearing. On almost all but one of the disputed points, Your Honour accepted the first defendant's request in the same formulation, albeit with some minor tweaks to one. And we say that much of that ought to have been uncontentious. It was clear why the documents sought were relevant to the pleaded issues. They were sufficiently clear in scope. And we should be permitted the costs of those. The problem, as we say it, is that the claimants did not adopt the approach that is envisaged by Part 28. So to put it in context, the first defendant made 17 requests, 13 were rejected outright, 4 were agreed, but those are the items where we say no relevant documents were actually disclosed. And so we've asked for them to be included in the document production order anyway. There was no meaningful intent to engage, and what we mean by that is where issues were originally taken about, for example, breadth, that was based on date ranges. And when we offered date ranges, there were new objections to breadth taken subsequently. But the direction of travel seemed to be, this isn't a genuine attempt to engage, it's just we're going to reject. And if we try to find common ground from the first defendant's perspective, we're going to find a new basis on which to object, come what may. Even with that, the objections taken on breadth, which actually consumed quite a lot of the oral argument, weren't really the operative cause of non-production. The main points that were led in the response to the document production schedule were the points taken on possession, custody, and control. In other words, the claimants were of the view that they didn't have to disclose Al-Khalij documents because they didn't possess them or control them. And much of the time spent arguing on the documents at the very least was based on that issue, which by the time we got to the hearing was dropped completely and ought to have led to production of documents much sooner. And the other, in relation to Health Insights Egypt, we say was misconceived at the outset because shareholders do not have a general right to company documents, and that should have been known and clear as a basis that the basis in which the objection was made was not one that was properly taken. By contrast, and this is the final point, we say that the first defendant has tried to approach this in the way that the court encourages parties. So of the 19 requests made, 10 were either agreed or offers to produce were made, subject to agreeing what we said was the more proportionate scope. And where there was resistance, we say it was with good reason. And to give 2 examples of that, one we've already looked at when it came to the bank statements and the documents with auditors, that was quite far removed from what was originally requested. So requests 10 and 11 originally were for all documents relating to the financial health and position of the second defendant over a 9-year period, which very much fell into, as I say, the Talim category of overly broad, impossible to search. Similarly, request 3 asked for emails passing between the first defendant and any employee of HI Dubai, HI Egypt, and or HI Malaysia, which referred to the authorship and ownership of MCC rights, again, over a 9-year period. It was in broad terms, which, subject to the clarification that was made at today's hearing, which made it clear it was about ownership rather than inferences of ownership, is something which was framed so broadly, it was perfectly normal and reasonable for the first defendant to take an objection. By the time we get to the reformulations, the timing and the procedural history is relevant. So these exchanges of schedules took place in November and December last year. The first defendant made its application for a document production order in January, and the claimant waited a period of 2 months thereafter, so it wasn't until March that they made their application. By the time the claimants had made their application, which adopted a narrower framework, quite a lot had happened in the sense that it was clear already that there was going to be a contested hearing, which was going to have to be attended come what may to deal with the first defendant's application. So that's the first point. The second point is it had become clear at that time that the position adopted by the claimants was an entrenched one, in that we're not going to disclose anything to you. And the concept of cooperation under the RDC somewhat is a two-sided thing. One can't expect one party to simply roll over and give one side everything it wants if it's not going to accede to reasonable requests for documents on its part. And so the initial attempts made by the first defendant to cooperate and to try and reach common ground was somewhat overtaken by the claimant's whole reluctance to engage. So it's not surprising that by the time we got to this hearing, the first defendant did seek to resist, again, we say on perfectly arguable grounds, the reframed requests that were being made. But in any event, by the time the reframed requests were made, most of the laborious costs in dealing with the applications had already been incurred, because those had to do with the first defendant's application. So we would seek an order in this case that the claimants pay the first defendant's costs to be assessed if not agreed. The alternative, if Your Honour wasn't persuaded by that.
Of both applications, or of, sorry?
Yes, of both applications, because we say that the narrowing efforts on many requests by the claimants came so late in the day that there had already been an inevitable contested hearing. Had there been early cooperation, it's always possible to have a more meaningful and cooperative exchange on what's going to be accepted and what's not. But by the time we got to March, when the claimants issued their application, it was too far gone by that point anyway.
Thank you, Mr. Jackson.
Your Honour, the order I invite you to make is costs in the case as regards both applications. In respect of the overall success of the parties, my submission is that both parties have had a fair measure of success on each of their applications that they pursued. In respect to the first defendant's application, there were 13 requests in issue. Of those 13 requests, one was not ordered at all. Amendments were made in respect of 5 requests, and the remainder were ordered as drafted. So I accept a fair measure of success for the first defendant on that application. In respect of our application, there were 11 requests. Aside from requests 12 to 15, which have been adjourned, the claimant succeeded on every request, save with some minor amendments to some of the wording. So this is a case where both parties have substantially succeeded on their applications, and where the starting point should be that the order be costs in the case. In terms of the conduct points that are raised by my learned friend, we do disagree that there's been any failure by the claimants to engage in the document production process. In respect of the first defendant's application, we raised objections in response to the application in our evidence. Those objections, in large part, Your Honour has ruled against, but they are ones which were reasonably taken. There were no objections which were clearly hopeless on their face. And in respect to the claimant's application, we did try to engage constructively to narrow the scope of what we were seeking from the first defendant. And actually, in respect of a number of requests that Your Honour has ordered we are entitled to, the request you have ordered to be complied with is the result of that narrowing process. So we don't agree, we don't accept the assertion that we haven't engaged constructively. And finally, in respect of the point my learned friend made at the end, that he seeks the costs of the claimant's application, in my submission, there's no basis for that whatsoever. The first defendant resisted the request as put in our application. That was issued in March. It didn't have to do so, and the costs of that application have been incurred as a result. So if Your Honour were minded to make an order that the parties do bear, or that the opposing party bears the cost of the application, the alternative order I invite Your Honour to make would be that the first defendant gets the cost of its application and my clients get the cost of their application.
All right, thank you. Having heard the submissions made by Mr. Doherty, I will order in relation to the defendant's application that the claimants pay the defendant's costs of that application. In relation to the claimant's application, I will adjourn the question of the costs of that application until I have determined the matter in relation to the adjourned questions, so that I can then determine the extent of the success that the claimants have in that application and take into account the questions of the conduct of the parties in relation to that application. All right. Anything else?
No, thank you, Your Honour. We will draw up orders as you suggest. We will also engage on the other issue.
Yes, please.
Yes, nothing else.
All right. Well, I thank you both and those instructing you and the court staff for sitting a little longer than we had anticipated. But thank you all. That concludes today's hearing.
Thank you.
Thank you, Your Honour.